18 years aged widow, my lord, they are not getting the family pension, my lord. This is very, my lord, the matter relating to the code number 18, my lord. 18 years widow, my lord.
Sir,
My lord, your lordship.
there is no urgency, sir.
My-
Let his lordship come.
Well, it is
before
covered.
your lordship. No,
It is
before
covered
his
by
lordship.
it is covered by the judgment, my lord.
All right, sir. His
Eh.
lordship's determination has been assigned
Right.
only for those matters which cannot wait till tomorrow. If you can come up with such a matter that it cannot wait till his lordship comes, of course I will take up.
But this matter will take only 2 minutes.
No, but that does not look nice.
My lord, may I permit? My
Sorry,
lord, this,
sir.
my lord, may I permit? My lord, this is regarding.
Seniors are there.
Okay.
Follow the rule. Take the mic. Take the mic.
Court number 18 matter, lordship.
Show me the urgency that it cannot wait till.
Husband is it is transfer matter. Petitioner husband is a cancer patient. He is
cannot wait till tomorrow. Then I will take up.
Sure, I have mentioned, lordship, kindly please. Her husband is cancer patient, lordship.
All right.
Lordship, kindly.
Let him come back. Mention before him.
Yesterday I mentioned, my lord, your lordship.
My list,
Yes.
my determination. Why? What is the urgency?
My lord, this is a BSF personnel who became, my lord, 99% disabled. After being disabled, his required benefit under the scheme, available scheme, was not, my lord, extended.
No question of upgradation in this matter.
Your lordship told me, my lord, to serve him, my lord.
Yes, but it is in the list.
My lord.
It is in the list.
Yes.
So I will reach, sir.
134.
I will reach, sir. When I will reach, then I will take up.
May I have my lord's kind leave to mention, my lord, this pertains to, my lord, item number 116 of your lordship's monthly list, my lord. Urgency is, my lord, 50 points roster has not been followed. The interview is to be taken up on 29th this month itself, my lord.
This month?
Yes, my lord. 29th, my lord.
Oh.
Just 7 days later, my lord. I have mentioned, I am mentioning about notice, my lord.
No, this month, 29th.
29th.
Pertains to my determination.
Yes, my lord.
Service.
Yes. Well, item number 116, my lord, of your lordship's monthly list, my lord.
29th of July.
My lord. Interview is to be taken up, my lord. Go it.
All right. 25th July top.
I'm
top.
grateful, your lordship.
Give notice to others.
Yes, my lord. I'll again.
Come with an affidavit of service.
Yes, my lord. My lord.
Motion top.
On 25th.
Shukurbar diye din.
25th, my lord. I'm grateful.
Yeah, my lord, may I mention, my lord, item number 471 of my lord Justice Bhattacharya, my lord. My lord, it is appearing in the list, my lord. My lord, the urgency is, my lord, the petitioner is very seriously ill, my lord. She retired before 4 years, my lord. She has only applied for house rent allowances. My lord, I mentioned before your lordship, his lordship asked me to show the order, last order. My lord, it was due to appear in the month of July 2024,
Let him
my lord.
come back then. Yes.
My lord, let me state the urgency only. The urgency part is
Justice Bhattacharya.
Yes, Justice Bhattacharya. The only part of yes.
It cannot wait till tomorrow.
My lord, the situation is such that at any point of time, the joint entrance result will come out. And in the event, if I succeed, I will not be able to take up admission in any BE college for the reason I was not awarded any marks in the theoretical exam of physics.
No, sir. The result has not yet.
No, in NIOS, my lord. This is National Institute of National Open School. Through National Open School, he has given his class 12th exam. Now, in the class 12th exam, he was not awarded a single marks in the theoretical paper of physics. Now, joint entrance, as a joint entrance aspirant, I have already given, and I'm expecting a good result out of it. But even if I succeed there, I will not get admission because I was not awarded a single marks in the theory of physics. That was my case. That was the petitioner's case, my lord. Petitioner is a student. In the event I miss this opportunity,
when the joint entrance result
is expected this month end, my lord.
28th motion top. 28th.
I have served.
Motion top. Give further notice informing, and if other sides are not there, I will not take up.
My lord, may I be
top,
permitted?
come with affidavit of service.
My lord, may I be permitted to mention? New motion, my lord. The urgency is that the petitioner is
Bhattacharya.
Code number 18, my lord.
Yes.
The urgency is that the petitioner is suffering from serious gynecological problem and she cannot travel 100 kilometers one way.
Let him come. Next.
The lordship, may I permit?
Yes, sir, now.
My lord, this is pension and retired benefit, my lord. Yesterday, my lord, I mentioned the matter and my lord to give the direction for the notice to the state. And my lord, I did this yesterday and my lord,
Notice to state you have given.
yes, my lord, yesterday.
Mentioning for what?
My lord, pension and retired benefit, my lord.
Huh?
Pension and retired benefit, my lord.
I have
Yes,
passed my orders.
yes, my lord.
Show me which order I have passed.
My lord, both are similar, my lord.
This is not my order. Prayer is allowed. Hearing of the writ petition is adjourned. Let it be included in the monthly list.
That is bit so pass.
My
নিয়ম
lord,
আছে 24
my lord, may I, my lord? He is my lord junior to me, my lord.
All right.
This matter is, my lord, regarding pensionary benefit. My lord, petitioner has, my lord, severe, my lord, medical issue.
Bhattacharya,
Yes, your lordship. Severe, my lord, problem, medical problem is there,
let
my
him
lord.
come back.
Lordship,
My lord, kindly, my lord.
No.
may I leave to mention one matter from the my lord justice?
No. He has done his job. He has done his job.
Yes,
Don't
yes.
don't blame him. He has
No,
done
my
his
lord,
job.
I find that he made
No.
wrong submission. my lord,
No,
that is-
absolutely not. He has made a fair and good submission. That's why I also did not allow to you. Pensionary benefit can wait till his lordship
But,
come back.
my lord, petitioner is, my lord, petitioner has, my lord,
Maybe I
recently
appreciate,
find out
madam. I
cancer, my
appreciate,
lord.
I appreciate, madam, but it can wait till his lordship
My lord,
comes.
petitioner,
I can take up only those matters which cannot wait till tomorrow. Like one, they have mentioned that within 2-3 days some result will out. So that matter I have
my lord,
entered. No.
understand, my lord,
Next.
our, my lord, problem, my lord.
From the list of my lord justice
Huh?
from the list of justice.
Sorry, I cannot hear you.
May I leave to mention one matter from the list of my lord justice Sugata Bhattacharya.
Yes. Show me that it cannot wait till tomorrow.
Wife of the petitioner is suffering from the serious gynecological disorder, your lordship, and after the verification from the CMOL, the application forwarded to the school service commission, your lordship. Thereafter, the application was pending before the school service.
All right. It will be done before his lordship.
May I be permitted to mention this matter for inclusion in the list? Even yesterday I had mentioned this.
Justice Bhattacharya's list or my list?
No, sir, it is from Justice Arindam Mukherjee.
Acha, what happened?
So the petitioner here, he was a former engineer in the state fisheries development. In 2023, he had undergone through a surgery, and for that he had taken some leave. During that period of time, the authorities had forcefully convinced him to submit his resignation.
Forcefully convinced him to submit resignation. He submitted resignation.
And
Now
after
he
that-
is asking for recalling of resignation. Yes. No urgency. September monthly list. Motion service. My order. First time.
No. Lordship, several order was passed. He prepared an appeal was disposed of. Set aside the order passed by the contempt.
Set aside the order passed by the contempt. I cannot follow, sir. I have passed an order. From
an appeal.
From that order, the contempt you are preferring. So my order was carried into appeal.
Yes.
My order was set aside. Then how contempt will lie?
Contempt application is pending. Lordship, let it be disposed of. Otherwise,
If my order is set aside, then that contempt has got no force.
no. Lordship, let the matter be acted and the contempt.
You are for contempt now. Acha. Show me the order. My order and the appeal court order.
Lordship, your lordship order not yet. Lordship, today I have not brought the order.
So unless I see, sir, how can I? Come and mention tomorrow. Produce the orders, mention tomorrow. It is the এখন? আচ্ছা, very well. দিয়ে দিন, চলো।
Lordship, may I be
But bring those orders.
Yes.
My order and appeal court order.
May I be permitted to mention one matter?
1st August দিয়ে দিন, 1st August. 1st August. Friday.
Lordship, may I be permitted from Lordship's list? One pension application I had made back in April. no decision has been given by the respondent authority saying that it cannot be determined until they have sought information from a third person, a person whom I don't know. I'm a student, Lordship, completely would be dependent on the pension benefits which I'll be getting, family pension. And my mother is severely ill, Lordship. I cannot treat my mother because I'm.
It is in the list.
It's in the list, Lordship. New motion. New motion, Lordship.
Appearing in the list.
Appearing in Lordship's today's list.
Today's list.
Yes, Lordship.
Item number?
83, Lordship.
If I call out, then.
Lordship, may I be permitted to mention this matter, Lordship? Group 2 matter, Lordship. Lordship,
Group 2 to আমার নেই?
Court number 18, Lordship.
Court number 18 from
Court number 18. Yes.
Lordship, he paid for transfer, Lordship, on medical ground, and he applied through.
No urgency. Next.
Lordship, another one matter. Lordship, his salary has been stopped by the school authority, Lordship.
No urgency. Let him come back.
petitioner school is not giving the inspection. The DLIT is not giving the inspection.
Let my lord come back.
Lordship, if I may be permitted for an inclusion in the list from Lordship Shogata Bhattacharya's list.
Show me the urgency that it cannot wait till tomorrow.
Your Lordship, the petitioner was posted, is an employee of Shamagro Shiksha Mission, and she was posted in Raniganj initially, but the respondent authorities transferred her to Asansol.
Before his lordship.
I have to mention one matter regarding item number 762, Lordship.
What is the matter urgency that it cannot wait till tomorrow?
Date of birth was wrongly recorded in the
Before his lordship. Next.
the compensatory appointment of the petitioner.
Before his lordship. Before his, no urgency. No urgency. Next.
The tribunal also that was not considered, Lordship, until and unless that
No urgency, madam. Yes. Yes, you.
My lord, may I be permitted to mention the motion interest on delayed payment of retail
Gratuity.
benefit. Yes, my lord.
My orders are there.
My lord, I have no knowledge
Justice
because
Bhattacharya's determination.
no, my lord. Yesterday, learned Advocate Parvez Anam mentioned it, but your lordship directed to serve the notice and come back.
Who you have served notice?
Yes, my lord.
How many matters are there?
My lord. Not very matter.
20 matters.
No,
Huh?
10 matters.
10 matters are
Yes,
there.
ma'am.
Give staple it and bunch. Give the bunch.
16 matters. 16 matters.
Staple it. দিয়ে দিন আমার অফিসারকে দিয়ে দিন স্টেপল করে রেখে দিন ওই যেমন আপনারা দেন না ভাগ ভাগ করে ইন্টারেস্ট অন গ্র্যাচুইটি
May I permitted to mention, my lord?
এটা কি ইন্টারেস্ট অন গ্র্যাচুইটি
Yes, ma'am. Gratuity. Yes, ma'am.
ইন্টারেস্ট অন গ্র্যাচুইটি করে দিয়ে দেবেন বাট আনলেস আদার সাইড ইজ দেয়ার উইথ প্রপার নোটিস অ্যান্ড অ্যাফিডেভিট অফ সার্ভিস not only that you have to serve the petition you have come back with the affidavit of service and my suggested orders are there my orders are there in every writ petition you have to bring each order correcting in the light of that particular writ petition then only I will take up otherwise lock stock and barrel will be delisted.
Your Lordship, may I permit to mention a matter for CAN application, Your Lordship. The matter was filed on 23rd May.
This restoration application.
No, it's a CAN application.
CAN, what you are paying for?
Your Lordship passed an order on 21st April 2025. So we comply. We facing a several difficulties to comply with such order, Your Lordship.
Huh?
We facing a several difficulties to comply with such order.
Acha, okay.
So we elaborate this point in this CAN application.
CAN এ দিয়ে দেবেন এটা যেদিন দেবেন লিস্টে দিয়ে দেবেন একটা.
May I permitted to mention, my lord?
Yes.
My lord, new motion, my lord, for inclusion.
My determination.
Yes, my lord.
Service.
Yes, my lord.
September monthly list.
My lord, from
Motion service September monthly list.
one matter from the urgent list of determination of Honorable Justice Shogata Bhattacharya.
Satisfy me, it cannot wait till tomorrow, then only.
My lord, it's an HRN matter, my lord, already decided by the coordinated bench of this
All
Honorable
right.
court, my lord.
Do it before his lordship.
My lord,
Next.
for the past 5 years, my lord, I'm not getting my HRA, my lord. Kindly consider, my lord.
Before his lordship. Next. Next.
পরের দিন নিজে করতে বলেছে
Yes. Yes. Where is the report, sir? ও আজকে দিয়েছো? আসুন আগে এটা লিখে নি। কি হলো? কাল কি করলে? কালকে তারপর সব তোমাদের ছেড়ে দিলাম, ছেড়ে দেওয়ার পর আধ ঘন্টা বাদে ওই প্রবলেম অ্যারাইজ করলো। সে হাতে লিখে মিনিট করে হাতে আমার সাহেবকে পাঠালাম। যাই হোক, আমাদের কিছু করার ছিল না বাবা। যাই হোক, ঠিক আছে। ইয়ে এসছে দেবাশিস এসছে, থ্যাংক ইউ থ্যাংক ইউ। দিদিরা কাল কি করলেন? কিন্তু কাল রাস্তা ট্রাফিক কিরম পেলেন যাওয়ার সময়? ঠিক আছে, একটু বেশি সময় লাগতে পারে কিন্তু বেরিয়ে যেতে পেরেছে। আমি তো এখান থেকে বেরোলাম তখন 8:30। ওই ইন্টারভিউ শেষ হলো, তারপরেতে ও বেচারিদেরও দেরি হয়ে গেল, ওরা বসেছিল দুজন। তারপর ওদের ছেড়ে দিয়ে আমি ঘরে এলাম 15 মিনিট বাদে, চা খাচ্ছি 15 মিনিট বাদে একটা ফোন এলো যে ওই ইন্টারভিউ এর মধ্যে কিছু মানে প্রসিডিওরে কিছু প্রবলেম অ্যারাইজ করেছে, কেউ কেউ আসতে পারেনি। ন্যাচারালি কালকে কি করা যাবে, আবার তার একটা মিনিট করে করে হাতে লিখে পাঠালাম। আবার আমাদের কমিটির চেয়ারম্যান সাহেব বাইরে, জজ সাহেব গেছেন গিয়েছে। যাই হোক, আসুন প্রথমে লিখি অন দ্য প্রেয়ার অফ, আচ্ছা প্রথমে লিখুন অ্যাপিয়ারেন্স গুলো দিয়ে দেবেন। On the prayer of Mr. Shantanu Kumar Mitro, Senior Government Advocate for the State, learned senior government advocate for the state, the report on affidavit. In নামটা নতুন coinage করেছিলাম report space on space affidavit. ঠিক আছে? Report on affidavit কি ভালো হয়েছে না? Report on affidavit filed in court today is taken on record. Paragraph. Identically on the prayer of Mr. Shahan Shah, learned advocate appearing for the petitioner, the exception is also taken on record. First, kindly come, both of you come to the last order. First, let me clear the Mr. Mitro, you show me 7 and 10 have already applied seeking transfer.
That is,
Page R7, R10. A petition R7. P7 page.
Lordship.
From the report. Let us eliminate first.
Lordship.
Then I will hear on merit.
Page 53.
For P7.
P7.
নাম মিলিয়ে বলো বাবা।
Kabir Ahmed.
নামটা মিলিয়ে বল। Please compare the name and tell me.
Petitioner number 7, Kabir Ahmed, page 53.
And R7. Annexure R7. Okay. Huh? Report. Fine. Then P10, petitioner 10. Page 56 R.
But this is a
Part of R7. Series of R7. Yes. All right. R7.
Altogether, Milord, petitioner 7, 10, 4.
Slowly. Now you come to the next part. Some of have submitted their representation in writing, wherefrom it would be evident that they have not accepted the decision for transfer.
Kindly takes.
They have not opposed the decision for transfer, and on the contrary, they have accepted.
Kindly takes page 50 of the writ petition.
So tell me petitioner number, which page? Accepted.
Yes. Page 50, Milord, kindly comes.
Page 50 for P, which number? Petitioner number?
Page
50, writ petition.
Yeah, page 50 of the writ petition, Milord. Their representation. Bishop number. Milord, petition number 4.
P4.
Petition number 4 at page 50.
50. They accept. He accepts.
What he says, kindly takes Milord.
Asked. Part of annexure.
Annexure, Milord. Page 50.
Page 50 of the writ petition.
Writ petition.
Absolutely. Oh, this is writ petition.
Yes.
Part of annexure P6.
P6.
Earlier two was of the report and this is of the report.
And
P6. Okay. Slowly. Next P, petitioner number.
Page 52, petitioner number 1.
52.
Yes. And Milord.
Page. Same P6.
52.
P6. Acha. Next petitioner.
Ashish Kumar Maiti, page 56, 7.
Petitioner number?
7.
No, 7. 10.
Petition number 10, page?
56 and
of the writ petition.
Okay, next.
Page 59.
Petitioner number?
Vijit Kumar Das.
8.
Writ
petition number 8.
Achha, next petitioner number?
Page Rajiv Mondal, page 62.
Paid petitioner number?
Rajiv Mondal 9.
All right. Then next.
Ovir Ahmed, Milord, 65.
Petitioner number?
7.
Yes. Next.
These are all, Milord.
These are all? Yes, Mr. Das. These are all. Both of you have checked up. These are all all the petitioners. They have accepted. Acha, now let me read. First, let me read that first part from the report.
But one more classification might be there. Petitioner number 4 and 8 were previously transferred. You'll also want inquired whether they were previously transferred or not.
So 4 and 8 were previously transferred.
And we not 4 applied on his own volition. He has been
4 applied.
Yes.
On his own volition and got the transfer.
Yes, and also we got petitioner number 8.
And aste বুঝতে পারবো না. Applied for transfer. And P8 applied for transfer.
Lordship on 9 to my report. On 9 to my report.
These two, 4 and 8, your lordship kindly makes an endorsement that is from our report. The report that is next to the report.
P4 applied for transfer. 1 second. And previously transferred.
Lordship.
Page P4 page.
Page below 53 onwards.
আবার বলে onwards একটা পাতা চিঠি
one paragraph. I have taken the personal
আশিস কুমার কত
from the client. What has
I'm coming. Let me clear the facts. I will hear you.
From my report, page 53, petition number 7.
Aha, page P4. Please tell me, petition number 4.
R7.
Petitioner number 4 applied for transfer. Page. এটা তো চার্ট করে আনলেই হয়ে যায়.
Page 59.
Page 59, R8.
Not transfer, but alteration of place of posting. There was no concept of transfer at that point.
Very well. I will hear you.
Page 59.
Page 59.
Petition number 4.
Petition number 4.
And R8.
Page 61. Petition number 6.
Petition number 8. Page 51 for
61 of
Acha.
report. Petition number 8.
And page 53, petition number 7.
That you have already said.
Already transfer হয়ে গেছে তাদের গুলো বলছি মানে ট্রান্সফার অলরেডি হয়ে গেছে 4 and 8.
আশিস কুমার বিশ্বাস and milord আশিসটা কত নম্বর থেকে milord petition number 10.
Ajay, you have read my judgment. That one I have.
Yes, we have read it.
Yes.
I have got the judgment for my.
I will see.
Lordship judgment পেয়েছি তো এই তো ওর কাছেই আছে না দিকে কথা বলছিস কেন কিন্তু আমি সেই দিনই বার করেছি হ্যাঁ এটা পিউরিটি না
I will.
It is, milord, your lordship held punitive transfer, that's why transfer order was set aside.
Forget it. First, let us clear the facts.
Yes, we have got it, milord.
So I take it P7, P10, 53 and 56 from the report. It will show that they sought for transfer. P4, P8, previously, according to you, previously applied for transfer and received transfer. 59, 61. That is according to you. I'm saying according to you. Then P4, P1, P10, P8, P9, P7, the respective pages showing accepted the transfer, right? Acha, let us now see the documents one by you place your petition. You place first from their report. Let us go by this serial.
We have challenged the transfer guideline issued by the West Bengal Health and Family Welfare.
Show me from your writ petition.
That is 44.
Let us 14.
prayer.
Let's read the prayer. Take the microphone, be louder.
Last prayer is we have prayed for set aside the order.
Read on. Read in the nature of mandamus commanding and or directing the respondents, their main servants, assigned to cancel, rescind, and withdraw the order being such and such. Which page, sir? 25th June.
It's a transfer.
Page 41, P4.
Issued by Mission Director, NHM Executive Director, West Bengal Health and Family Welfare Committee. Acha. Written the nature of mandamus commanding and or directing the respondents, their managers, servants, assigns. Not to give an further effect to the transfer guideline. Very well. Eta ki? What is this? 26th May.
That is transfer guideline.
Show me the page.
Is 44.
You have paid court fees for 10?
Yes, minute.
You first satisfy me. Acha, show me page 44. Transfer guideline. Transfer guideline. Then the transfer order is 41.
My Lord Miller presents.
My
Lord presents. May I just only add one line for my Lord's kind convenience, but I got the information. Then, my Lord, you will also may.
You take up the cause.
No.
Proceed. He will do afterwards. You take your seat, sir. You assist now, Mr. Bhattacharya.
West Bengal State Health and Family Welfare Committee, it is a society registered under Societies Registration Act.
Yes, I'm coming to that. First question would have been, that's why I have said, where are those two documents? First, satisfy me that you can maintain a writ petition.
That's the reason I'm just indicating to my lords. And your lordships will be pleased to find that both these transfer guidelines as well as
the order issued by them.
Right.
Show me.
And I ask the clients further one thing, that If it is a society registered under the Societies Act, then how these persons, that is the mission director or the particular executive director of West Bengal State Health and Family Welfare, they are issuing the order? Are they been given a power, or they have been?
But it shows that the guideline issued by Shomiti.
Guidelines issued by
Shomiti.
Shomiti. Yes, yes. This is
also by Shomiti. How can you maintain a writ petition?
Right. Now, Millard, I say, Millard, with the greatest of respect, today I'm not fortified, but I can show to my lords by tomorrow that there are two sets of views. One view is that at the instance of a registered society, writ petition is maintainable.
And the instance is different. I'm saying against a registered society,
a writ petition is maintainable. Why I say? Because I will be showing those judgments. But if it is an unregistered society, I have no locus, and Millard, I should be candid, Millard, don't take me amiss. There in the Shiliguri Bar Association, in the circuit bench, Millard, I am appearing for one of the parties, and they are the honorable judges, Millard, my lords, when going there, had asked that you take sufficient time, get any judgment of the, even the other courts, that unregistered society can maintain a writ petition.
It is not can maintain, it is can be maintained against.
I'm sorry, my language is, I tender my unqualified apology. But Millard, till date my searching is not yet complete, but I did not get it. Now Millard, ঠিক আছে, সেটা দেখবো।
How can maintain a writ petition against an action of Shomiti, which is a registered cooperative society under the Societies Register Cooperative Societies Act?
Whether it is a cooperative society, it has been registered under the Societies Registration Act.
If it is a body under Societies Registration Act, then how a writ petition can be maintained?
Permit me, if I get, I can place it to my lord. If I don't get, I will not be placing the matter. And one thing more which I find, which I should also, just 1 second, because Millard, at the cost of repetition.
Sir, if you want to come back on a further day, better come back on that day.
Very well.
Remember, Millard, we are suffering an interim order.
Interim order? What interim order?
Interim order কেউ কিছু হবে না।
All right, I'm giving an ultimate time. If they complete on that day, complete, or interim order will be vacated. If they ask for time. Or if I can hear them on merit, I will hear them on merit.
We have not subject to correction, as the order sheets will reflect.
I don't find any interim order.
Yes, first day, in the first day, your lordship kindly, Millard, granted.
Yes.
Sorry, 4th of July.
আছে লিখুন। From the report on affidavit filed by the respondents. আচ্ছা, তার আগে একটা লাইন লিখুন। The last order dated July 10, 2025 speaks for itself. তারপর, from the report on affidavit filed on behalf of respondents, it appears that petitioner number 7 and 10 . have not opposed the decision for transfer, and on the contrary, they have accepted the transfer. Full stop. Such facts would be evident from pages 53 and 56, being annexure R7 to the said report, comma, as submitted by Mr. Mitro, United States Council.
Only one thing I would be adding. Kindly take.
Sir, it is his submission as submitted. Full stop. Because on the next day I can get the ready reference of the pages.
Of course,
And this note I will throw it out.
আগে তো আপনাকে দেখলাম
কি বললাম? Respondent number 7 and 10.
যেখানে আপনাদের জায়গা সেখানে দেখেছি।
হ্যাঁ, একটু আগে থেকে পড়ো।
আমি তো সুপ্রিয় থেকে
না, 7 and 10 already 7 and 10 have already applied seeking transfer, as would be evident from pages 53 and 56, comma, annexure R7 to the report. Paragraph. Comma, as submitted by the Learned State Council. Paragraph. Petitioner number 4, 1, 4, 7, 8, 9 and 10. 1, 4, 7, 8, 9 and 10. Have submitted their representations in writing, wherefrom it would be evident that they have not opposed the decision for transfer, and on the contrary, they have accepted, as would be evident from pages 52, 50, 65, 59, 62 and 56 to the writ petition, as submitted by the Learned State Council. Paragraph. Learned State Council further submits that petitioner number 4 and 8, out of their own volition, applied for transfer, and they were transferred. Full stop. Petitioner number 4 and 8 have accepted transfer. As would be evident from page 59 and 61 to the report on affidavit. Full stop. Paragraph. Learned Senior Counsel for the petitioner, Mr. Bhattacharya, has opposed these submissions. Full stop. He denies and disputes these submissions. Full stop. These submissions. Full stop. Paragraph. On the question of maintainability of a writ petition against the respondent number West Bengal State Health and Family Welfare Committee. It's bold, huh? West Bengal W cap, B cap, State S cap, Health H cap, Anta Chinno, Family F cap, Welfare W cap Committee. Of this writ petition. Which is a registered society within the meaning of the Societies, West Bengal Societies Registration Act 19.
It is under the West Bengal Societies Act, registered 1961.
Under the West Bengal Societies Registration Act
1961.
It's a cooperative society. Look at mobile. Google.
I'm searching. I'm searching.
Do it. 1961. কি বললাম?
On the question of it is a registered society within the West Bengal Society Act 1961.
আবার শুরু করুন একবার। Comma, Mr. Bhattacharya, learned senior counsel, shall argue on the next day, and accordingly he prays for an adjournment of today's hearing, as he wants to rely upon certain decisions. Full stop. Paragraph. Such adjournment has been opposed by the learned state counsel on the ground that an interim order is prevailing, which was passed on July 4, 2025, and the respondents are suffering. Be that as it may, for the ends of justice, the prayer for adjournment is accepted. The writ petition shall appear under the heading motion top on July 29, 2025, comma, when the point of maintainability shall be decided first.
And one thing I point out, in the meantime, during pendency of this writ petition, during
microphone,
I'm using the mic. During pendency of this writ petition, the petition number 2 has been released from his office.
Released.
But
no coercive step taken.
But he is not allowing to sign in the attendance register. He may be allowed to.
No. Nothing.
Interim order is till the next day.
Interim order is there. What is the language of the interim order? What is the language of it?
Without leave of the court cannot be given effect.
Yeah, so you have to take leave. Yeah, it is there. Yes, I have directed that.
Let him stand beside on my right hand side. I have some difficulty here. Let my junior stand on my right. Now I appear for the petitioner on this.
Yes.
I've come the petitioner has come before your lordship challenging an order of.
Take the microphone. Because the acoustic in this courtroom is really problematic.
I'm sorry.
Okay. Yes, Mr. Shen.
Petitioner has come before your lordship challenging an order of transfer which has been done without following the existing rules of the company. The lordship will kindly come to page 100 first. This is the transfer order.
Slowly, go slowly. Not to hurry, go slowly.
Page 100, my lord.
That's the reasoned order.
This is the transfer order.
No,
This
this
is
is not
under
the-
challenge.
This is not the reason. order.
Let me place it, my lord.
It's written reasoned
This is a
order.
reason-
Earlier.
All right.
Yeah.
Take your seat.
Oh, no, no. Right, Lordship is correct.
Take your seat. Take your seat.
May I place the order, my lord? In compliance to the directions issued by the Honorable High Court at Calcutta, that is your lordship's own order, my lord. In the above referred writ petition, a hearing was conducted on 14/7/2025 by the undersigned authorities, respondent numbers 3 and 4, after due notice was served upon the petitioner, both physically and through his registered email. During the said hearing, the petitioner, Mr. Pankaj Kumar Jha, was afforded an opportunity to present his case in respect of his two representations dated 6/6/2025 and 19/6/2025, wherein he challenged the legality and fairness of his transfer from Kolkata to Bengaluru. These were not considered. I'll come to those letters after this. Upon careful consideration of the petitioner's submissions and all relevant records and policies governing transfers, the following facts and rationale have been noted. That as per the terms and conditions stipulated in your appointment letter dated 27/10/2005, you had duly signed and expressly agreed to accept posting and a transfer to any office, unit, plant, or site under the jurisdiction of the corporation across India. That in terms of circular number so and so issued by the
one
Central
second, 1
Vigilance
second.
Commission.
You tell me the page of that appointment letter.
It's at page 32, my lord. 32, P1.
30.
32.
32. Yes, proceed.
Paragraph 2, Mana, that in terms of circular so and so issued by the Central Vigilance Commission dated so and so, organizations falling within the advisory jurisdiction of the Commission have been directed from time to time to identify sensitive posts and to implement periodical rotational transfers of officials holding such posts in order to uphold transparency and integrity in administration. Based on records and prior requests available on file, you have on earlier occasions been accommodated with transfers to locations of your choice. Therefore, the present transfer being made purely on administrative ground, no other reasons, in compliance with applicable vigilance guidelines, cannot be said to be arbitrary or unfair in any manner. That you have been continuously posted at the same office for a period from 18/7/2016, 8 years, 11 months, and 26 days, and such prolonged tenure at the location, particularly in the context of a sensitive post, is contrary to principles of rotational transfer as mandated by applicable administrative and vigilance guidelines, and your transfer has been effected on valid administrative grounds, and no malafide or arbitrariness is found in the said decision, as the transfer was done in accordance with para 26(1) of IRCT's general conditions at Bargurvi.
Where do I get that?
Of service.
Why do I get that?
This has not been annexed. This has not been annexed by us. We have not annexed statement.
When you are carrying that.
But this is not applicable as such. It's this
but I have to read that. It is not applicable.
He has to take instruction because the client is not ready.
All right. Proceed.
When this order was passed on 14th.
14th July.
14th of this month. 16th I received my note. And I was asked to join the transfer within 4 days. So today is 21st, 22nd. I did not have the time to collect all the, this guideline. I did not get the opportunity to. I would have annexed it. I can do. Dite parbi client kothay? But this is not applicable. What I'm on to is there's a separate transfer policy. I'll be referring to those transfer policies.
Absolutely, but I have to read that also.
Your transfer has been effected on valid administrative grounds, and the third paragraph 5, and no malafide arbitrariness is found. This is a repetition of the earlier paragraph, my lord. They have quoted the terms of transfer. The position previously held, this is Mr. Mani Raman. At his place, he has retired. So I've been transferred there. He's a DGM under grade 4, my lord. And I am an assistant manager under grade 2. I don't qualify for that post. That's one of my ground.
Which is the higher one?
DGM is the highest post. DGM post, man retires. I am an assistant manager. I am being transferred to the post of without any promotion.
That's the next question I was about to ask.
Without any promotion, just go there and join the post
and discharge that function
at once for within 4 days. Wait, and we'll come to the transfer policy, my lord. In view of the light of the operational exigencies and administrative requirements, it became necessary to fill the sensitive post on an urgent basis. What is the urgency? After due internal deliberations, it was decided that Mr. Pankaj Kumar Jha, who holds the requisite, I don't hold the requisite qualification of a DGM, who holds the requisite experience and designation as assistant manager, not DGM, my lord, be posted to the said position at Bengaluru to ensure continuity of work and avoid any disruption in critical functions. The petitioner's representations, while noted and appreciated, nothing has been discussed, my lord, do not disclose any overriding hardship or ground to interfere with the administrative judgment made in the broader interest of service exigency. In view of the detailed explanation, my lord, I have been asked to join the transfer board within 4 days.
Yes.
Your lordship will now come to page 103. Annexure P24. P24. Next page. My lord, I was working under the finance department. Your lordship sees number 2, finance.
Yes, sir.
My lord, AGM, there is one post vacant in South Zone. That is column.
Finance department.
Finance department.
Yes, this.
When the post is AGM, my lord, under South Zone SZ. The column is SZ.
AGM. You are AGM.
No, I am an AM, assistant manager. I'm
Achha.
showing you the posts which are vacant. AGM, one post under South Zone and vacant, one post under East Zone.
কোথায় দাঁড়াও?
Finance under the heading.
Wait. South Zone 1. আরেকটা কোথায়? Where is the other?
The last column is East Zone.
Achha,
The
East
first,
Zone
second,
1.
third. The third column is South Zone.
Yes.
My lord, finance, the post AGM, there is one vacancy in the South Zone and one vacancy in the East Zone. Joint General Manager, there's one vacant post. There's no vacant post in South Zone and there no vacant post in East Zone.
So again, JGM.
JGM.
4 in the South Zone and 3 in the East Zone.
My lord, now the important part, DGM. The person who has retired is a DGM.
DGM.
DGM. There are South Zone, there are already 4 vacancies. And there is 3 from the East Zone. I'm from East Zone. They could have transferred one of these 3 persons to Bengaluru instead of an assistant manager.
No, one second.
The post,
No, wait.
the person who has retired in Bengaluru is a DGM.
You traveled from?
I am from Kolkata.
Kolkata to Bengaluru.
Bengaluru. My lord, I'm an assistant manager.
Right.
But there are three DGM posts, persons in East Zone.
DGM vacancy.
There are number of posts, vacancy na to. There is a
Number of posts. Number of posts.
A number of posts. So three DGM from East Zone is there available. They have not been transferred.
Three
I'm an assistant manager.
3 persons are already working. So one could be
transferred to Bengaluru, not an assistant manager who's in an inferior post, doesn't have the experience, doesn't have the qualification. I've been asked to go and join Bengaluru and do the works of the DGM. That's not a promotional transfer.
So you were sent from where?
From East Zone, Kolkata.
But assistant manager?
There is only two
posts.
No post in South Zone. There is no post in South Zone. Assistant manager, there are two posts in two people are working in East Zone.
East Zone.
I have been asked to join to Bengaluru. Not a DGM. I am an assistant manager. I'm hoping on that. Your Lordship will now come to page 54. The transfer policy. এখানে তো কোন নাম্বার অফ পোস্ট কোন জায়গা তো বলেন ছেড়ে দে Lordship will kindly come to page 54, the transfer policy.
Yes.
My lord, it is a rotation. They say that it's a rotational transfer. On a sensitive post.
And three things: sensitive post, rotational transfer, administrative exigency.
But the policy deals with rotational transfer so far as I am concerned, my lord. Page 55, your lordship comes. Rotation under the heading rotational transfer. May I please?
Wait. Kindly come to page 54. Bottom. Type of transfer. Type of transfer. Read. Competent authority may transfer. Competent authority may transfer an employee from one post to another / from one place to another on administrative ground, including routine / rotational transfer. Next one is not your case.
Ground, including routine and public rotational
transfer. I'm on rotational transfer.
Yes. So this prima facie shows that clause A on administrative ground, including routine / rotational. transfer.
Absolutely.
So routine can be done, rotational can be done.
Administrative.
Administrative exigency, if is there.
My lord, can I put this question to, and I'm asking this question to myself. In a vacant post of DGM, without it being a promotional transfer, can an assistant manager be asked to go and join the?
That's the second question. Yes, that's the second question. So, insofar as this clause is concerned, there is no problem. Had it been a DGM to DGM, DGM to DGM, perfectly fine. You are questioning, you are an assistant manager. How can you go and discharge the function of a DGM without promotion, without benefit?
Qualification.
Not qualification. They say, they consider you have sufficient experience. So I take it. For the time being, I take it. But if you have to discharge the function of a DGM, then why will you not be provided with the benefits of a DGM?
I'm out on too much.
Is that all? For the
now, consideration part, page 55. Just below rotational transfer. This is where I'm relying on, my lord. Request for transfer. Now let me go to the rotational transfer part. And when we place the rotational transfer.
Yes.
IRCTC employees holding sensitive posts and frequently coming into the contact with the public and the contractors or and associated with the passing of bills should be transferred every 3 years. It should be kept in view that such.
One second. Here also, every 3 years, you are working already 8 year plus. So
I have been already transferred thrice. And there have been, I will show to your lordship.
Maybe.
People have been working for 18 years in the same post.
Maybe.
That is one of my points raised before the authorities.
Maybe. But for this post as AGM in Kolkata, you are working 8 years plus. Carry on.
ঠিক আছে তুমি যেটা বলছো তুমি It should be kept in view that such staff are shifted with different sections on the same station without dislocating them from present place of posting. However, where it is not possible, the staff should be transferred to a different station, and for this purpose, options of station in priority may be obtained from them. No option was.
Wait. It's so illegible, my copy.
The option this option was not given.
No, I cannot read it.
It's not legible. When I got this brief just 1 hour before this matter was called. So it's prepared. একটু দেখে দিবি তো এগুলো তো
All right.
They did not ask for any option from me. Now come, what should be considered?
You leave it on your junior to read this portion. Ask him to read this portion. Read. Rotational transfer. Read.
IRCTC employees holding sensitive posts and frequently coming into contact with the public and or contractors and associated with the passing of bills should be transferred every 3 years. It should be kept in view that such staff are shifted within different section on the same station without dislocating them from the present place of posting. In our case, it has been in the different place. However, where it is not possible, the staff should be transferred to a different station, and for this purpose, option of station in priority may be obtained from them. However, an employee due to retire within a period of 2 years should normally be excluded, which is not applicable in our part because the petitioner is retiring in 2038, my lord. And the next, my lord, is the consideration, the request for transfer of staff to a station where employee's spouse is working.
That is not your case.
No,
You
we
have not
prayed for.
That is applicable in my case. My wife is not well. She's working in
No,
Kolkata.
you have requested.
Yes, I have. I'll be coming to those representations, which were not considered at all. The request for transfer of staff to a station where employee's spouse is working would be considered sympathetically, having regard to the administrative convenience. Whenever a suitable vacancy occurs and is not covered by redeployment, redundancy, and retrenchment, the staff member shall be placed in the first suitable and mutually acceptable vacancy. A suitable vacancy is one which makes an appropriate match between the officer, the job, and the works environment. This was not considered. Mani, your lordship will now come to
You show me your
page
application.
57. Right?
You show me your application.
There are two applications, my lord. This is the page 88, my lord, annexure P18.
Date
6/6/2025.
Page.
Date 6th June 2025.
Page.
Page 88 and 89, my lord. I will be placing the relevant portion, my lord.
Wait.
পুরোটা পড়বো।
Yes.
Let me place the page 88 first, my lord. This is, I need to place the entire letter, my lord. With due respect and humble submission, it's addressed to the Director of Finance, my lord. With due respect and humble submission, I wish to place the following facts before your kind consideration for a favorable decision regarding my posting. I joined IRCTC in the year 2006 as Supervisor Finance and Accounts and was initially posted at the Zonal Office, Kolkata, where I discharged my duties diligently until July 2009. Thereafter, I was transferred to the Regional Office, Patna, on my own request. After serving for 8 months in Patna, I was transferred again on 16/3/2010 to the Regional Office, Guwahati. During my posting in Guwahati, I got married on 21/3/2014 to Mrs. Kavita Kumari, a scientist at ICAR CIFRI under the Department of Agriculture, Agricultural Research and Education, Ministry of Agriculture, Government of India. She specializes in fish genetics and breeding and is posted at Barakpur, Kolkata. Her position is research intensive and location bound, making her non-transferable. Owing to her health concerns and based on the outcome of with petition 5068, I was transferred back to Zonal Office, Kolkata on 16/7/2016 on own request. Because on the ground of my wife's health, my lord. I now have 2 young children, the elder being 9 years old and the younger below 3 years of age. My wife and I share parenting responsibilities. However, our professional duties occasionally require one of us to travel, creating significant challenges in managing our household and children during such periods. My aged parents residing in Madhubani, Bihar, have developed age-related medical issues post-COVID-19. I must frequently visit and support them, which further compounds the personal and logistical challenge of being away from my current posting. Paragraph 6 is very important, my lord. As per the Department of Public Enterprises DPE guidelines, number DPE guidelines 2C15, provisions exist for posting of spouses. This is very important, my lord. At the same station, particularly when one is employed in a PSU and the other in the central government organization. When I am posted in public sector, PSU, and my wife is in the central government. Para 6 of the guidelines recommends accommodating such requests even in absence of an immediate vacancy. Even in absence of an immediate vacancy, by posting within the same state non-transferable, while mine is more amenable to relocation. Therefore, I respectfully submit that retention in Kolkata aligns not only with policy, but also with practical family and organizational needs. Having both parents present in crucial for the emotional and development well-being of young children, especially in the formative years. A stable posting enables me to support my family without compromising on professional duties. Post-COVID, dual career families, especially those with young children and dependent elders, face greater challenges. Compassionate and policy-aligned decisions in such context have been made in the past, and I hope for similar empathic consideration in my case. This letter was not considered, my lord. Your lordship will now come to the next page one, the second one. These two were placed before the. May I place it, my lord? With due respect, I wish to reiterate my request previously submitted for a posting at the zonal office Kolkata on spouse and humanitarian grounds. I would like to bring your kind attention that Sri Anil Bharti, MFF, Manager Finance, a colleague of mine, has been continuously posted in Delhi NCR region for the past 19 years on spouse grounds, as his spouse is employed with the Education Department of the Government of Delhi. Additionally, several other officers in the finance department have also been posted at the same location for extended periods to support their respective family circumstances. These include, the names have been given, one is 18 years. The number 2 is Sri Mani Raman,
All right.
at whose place I have been transferred. S. Sri Mani Raman, DGM Finance, who was posted in Bangalore for 19 years.
All right, then it is pertinent. Next paragraph. It is pertinent.
It is pertinent to mention these officers have remained at a single location throughout their service, while I have been transferred 3 times during my tenure. At this juncture, I am facing considerable family challenges. My elder child is 9 years old. My younger one is not yet 3. Due to professional constraints, my wife is unable to relocate to Bangalore, making it increasingly difficult for us to manage my family responsibilities, particularly the upbringing of our young children. In the light of the above, I earnestly request you to kindly consider my application for posting at Kolkata on spouse and humanitarian grounds. I would be deeply grateful for your support and understanding in this matter. These 2 letters have not been considered, where they have transferred me. None of these points have been dealt with. Page 50. Page 50. 50. My lord, your lordship will kindly come to page 50.
Page
Now, this is the personal policies under the service heading, the service matters. 2, 3, 4. 2, 3, 4, 5.
This is the policies of whom?
My letter.
Who follows this policy?
Here, ma'am, the DP guidelines for transfer policy, my lord.
No, but in your organization, if you have your organization has its own policy that we'll have to follow.
Your Lordship kindly comes to page 63.
Yeah.
Yes, my lord. Well, the first one, page 63, point number 1. DOPT guidelines endorsed by IRCTC.
63, my lord.
Page 63.
Wait. No. Which one is your policy?
Both. The transfer policy read with this DOPT policy.
Pages?
Pages 50, relevant portion is at page 52, point number 6.
And?
Point number 6, Roman 6.
And?
Page 76. It is the latest policy. It's 77. My lord, and the relevant portion is at page 77.6, where one spouse belongs to a central service. This is the latest.
All right. So let me hear your other side.
So far, my lord, I'll start, my lord, by placing your lordship's order.
The microphone properly.
I'll start, my lord, by placing your lordship's order, which your lordships had passed in the last occasion when the same petitioner, my lord, had moved this honorable court. But that's at page, my lord, 94, my lord, 94.
94.
Annexure P1, P21.
Yes.
The grievance of the petitioner is recorded in the third paragraph of first page. Petitioner being employee of the petition respondent number 2 has been transferred from
louder and take the microphone.
Transferred from Kolkata to Bengaluru. The petitioner submits that while issuing the transfer order of the petitioner, the employee has not followed the transfer policy prevailing on the issue. Hence, the transfer is bad. Referring to 2 representation dated such and such, I'm not mentioning that. London Senior Counsel submits that these representations have not yet been considered in accordance with law. Then that my submission is recorded. I am omitting
your submission?
my submission very well. Learned Counsel appealing for the respondent submits that the transfer has been effected in strict compliance of the transfer policy and following the due process of law. There is no malafide or arbitrariness involved while transferring the petitioner from Kolkata to Bengaluru. The petitioner is an assistant manager and belongs to a sensitive post. The administrative requirement and exigency needs the petitioner to be posted at Bengaluru, according to the employer. After considering the liable contention of the parties and upon perusal of the materials on record, this court first reiterates the settled principles that transfer is an incidence to the service. If there is any administrative exigency, the employer is always at its discretion empowered to transfer employee from one place to other. To meet such administrative exigency, whether as it may, in view of the above, the Respondent number 4, upon issuing a clear 72 hours notice upon the petitioner, both physically and an email of the petitioner wherefrom the representation at page 76 was sent to the respondent number 3, and after granting an opportunity of hearing to the petition, shall decide the said two representations by passing a reasoned order positively within 10 working days from the communication of this order. The reasoned order shall also be communicated to the petitioner immediately upon the same being passed through email of the petitioner. It is made clear that this court has not gone into merits of the rival submissions of the parties, and they shall be at liberty to urge. Yes. So, Milord, now in terms of this, the hearing was given. There is no allegation that sufficient hearing is not given. There is no allegation that due notice was not given. There is no.
Has he joined?
No. So,
he has not.
He is not joined. The time has expired on 19th of 20th was the day for joining. He did not join because 4 working days were given. For those 4 days expired subject to correction yesterday, day before yesterday. Saturday he did not.
We are hearing the writ petition.
Now I am saying that it is not the case of the petitioner that this notice was not given or the hearing was not adequate or not proper, or he was not allowed to participate.
He has not said so.
Yes, that is not the case here. That he has to then confirm, because Lordship had categorically permitted us, or rather directed us as CTC to give him a hearing on the basis of his representation. He today now whatever is there in the representation is
the reasoned order. The representations are more on wife's working place.
That's what he said in those letters. In these letters, demands of justice, in those 2 letters of June.
The representations which were before you,
yes,
do they contain the same contention that the wife is working here?
Wife's contention is there. If Lordship kindly reads
if the wife's contention is there, then what is your policy? Show me.
That document they have not annexed the general conditions of contract. I have referred that document in the recent order, but it is not annexed. I can come back with that copy of. I have a copy. I can come back with a copy of that. The general conditions of contract that categorically says how to deal with transfer policies of our institution.
And your transfer policy? Do you have any specific transfer policy?
For sensitive post, yes, Lordship has already observed. For sensitive post, that policy is there. That Lordship has already seen.
So where is that policy?
The Lordship was seeing that same policy on page 55. That is the.
Show me the policy. Argue on a policy that what you have done, it is in accordance with your policy.
But then in that case, I have to read that policy with the general conditions of contract. Kindly will allow me to come back with the general conditions. I have written upon that.
Come back.
And there is one further document which has not been annexed, which is yes.
2 things to look at it. 2 things to look at it. Since your learned friend is seeking some time to produce the appointment letter which contains the contract between you and your employer.
That is annexed. That is annexed. I am saying the general conditions of contract. Which
very
part
well,
is that?
Very well. Very well. Very well. And he wished to read that along with page 55.
Yes. Yes.
Right?
Precisely so. That is the.
So 2 ways to look at it for the time being. I'm at the motion stage. Either you allow him to continue without prejudice to your rights and contentions at the Kolkata office as he was. Right? So that you can get his service. Once the matter is pending before this court, once the writ petition is pending, I will definitely protect so that he shall not be alleged for any unauthorized absence. Let me complete, then I will hear you. Because he has come up with a particular case. May sustain, may not sustain. That's at the final stage.
Final stage.
Final stage. So you allow him to resume wherever he was, receive his service, right? So that he can be paid, everything will be all right, no unauthorized absence. And no further coercive step shall be taken without leave of this court. Second, you file an affidavit, you disclose these, whatever you want to disclose, whatever points you want to get ready, right? I'll give you a file a report by way of affidavit. He shall contradict that by way of an exception in the form of affidavit, and I will hear it again. Now you say, what do you say to this?
It's a proposal from, it's a Lordship has expressed Lordship's mind. So that I would not only request you.
Keep an alternative also.
Alternative.
If that is acceptable to court, of course I will accept that.
Request of explanation. May I give an alternative? Because previously, when other employees of the same institution, when they come to court and approach this court with the same allegation and with the same particular relief regarding the wife's accommodation or health condition, this court has observed that this task of hearing him and giving him, that can be done, but he better join. And in the meantime, court hears it. And ultimately, if the case...
I'm coming to that.
So that I am carrying one such order of this court. Of course, a single bench, single judge, honorable single judge, but I am carrying that order.
Mr. Sengupta,
same orders happened.
I have also passed my orders that you go and join without prejudice to your rights and contention. No coercive steps shall be taken.
Yes, I'll not take any coercive steps.
Let them file affidavit.
But the question remains, if I join, so I'm joining to the post of DGM.
Correct. It is, yes.
That I can answer. That answer I have right now. He is not joining in the because the Lordship kindly sees the transfer orders. The post is the post is not mentioned there.
Show me.
So then it's not a rotational transfer.
Show me. Show me.
Give me 1 minute.
Show me. Where is the transfer order, sir? Page.
It's at page 100.
100 is the reasoned order.
Transfer
order.
Page 87.
87. In the same grade and capacity.
Which is
clear enough.
Paragraph 1.
Clear enough.
My lord, there is no, my lord,
Presently
financial lordship kindly comes to page 103.
Presently posted, hereby transferred and posted such and such in the same grade and on such and such. Whatever he is doing today here, the same thing he will do there.
Not he will do, same grade and capacity. Which means today he is assistant manager, he will be an assistant manager.
Yes.
I will clarify that.
So there is no...
My lord, your lordship kindly comes to page 103 once again. 103.
Yes.
My lord, another heading, finance. I placed this, my lord. I'm in the finance department, my lord. Your lordship comes to the post AM. My lord, on the south zone, there is no post of AM.
That is not your lookout.
That is my exigency. I will...
That is not your lookout. He will go and join as AM. As AM without prejudice to his rights and contention.
তাহলে ওটা কথা বলে ওটা বললে কেন বলছে in place of the person who will সেটা কথা বলা আছে My dear lordship will now come to page 101 what they have stated in the reasoned order. It's
no without prejudice.
One last thing, one once. Page 101 that they are saying to join the position previously held by Miss Sri Mani Raman at the Bengaluru office.
No.
I will clarify.
No, that's not written there.
But the post of Maniram is been vacant, my lord.
I will pass my order.
Same duties, not the same posts.
I will pass my order. You will join without prejudice to your rights and contention there as an assistant manager. Right? And your joining at Bengaluru as assistant manager will abide by the result of this writ petition.
Yes, absolutely.
Ashu.
And Lordship will give this. I have one request. The Lordship will give me.
এই ঘরে ভীষণ acoustic problem.
I have one request, not two requests. In fact, Lordship will kindly mention that this order will not create any precedence in respect of the other employees because yes. And secondly, Milord, kindly give some preference to this matter because if we are stuck here, then maybe yes, those are the two. Nothing else.
Done.
I'm grateful.
This is the second. Acha, তার আগে Mr. Doipayan Sengupta, Learned Counsel, with Mr.
Samrat Depal.
Samrat Depal, Learned Advocate, appears for petitioner. Mr. Shoroshij Dashgupta, Learned Counsel, with Mr.
Miss Afrin Begum. I'll give the names.
Appears for the respondents. Correct? Now both of you hear me. This is the second round of writ litigation. Poster. The sole grievance of the petitioner is that the petitioner, being an employee of the respondent number 2, respondent number 1 has been transferred from Kolkata to Bengaluru by virtue of a transfer order dated
88 is 6 June.
June 6, 2025. Annexure P17 at page 87 to the writ petition. Full stop. The petitioner in the previous writ litigation has challenged the same on the principal ground that the employer, while issuing the transfer order, he did not follow the prevailing transfer policy, and hence the transfer was bad. Paragraph. The first writ petition was moved. Full stop. By an order dated July 4, 2025, annexure P21 at page 94 to the writ petition. This court disposed of the said writ petition, directing the respondent authority to consider the case of the petitioner in the light of the two representations submitted by the petitioner as mentioned in the said order. First. Pursuant to and in terms of the said direction, made in the first writ petition. The respondent authority has passed its reasoned order dated, impugned reasoned order dated July 14, 2024. Annexure P23 at page 99 to the writ petition. Full stop. The impugned order shows that the petitioner's challenge, apostrophe, Didi? Petitioner's challenge was rejected on the ground that due to administrative requirement, the transfer was caused, and such provision for transfer was agreed upon by the petitioner when he has joined the employment and the relevant and under the relevant contract of service between the respondent number 1 and the petitioner. The impugned order shows that the petitioner has been transferred at Bengaluru in place and has been directed to join in place of one Sri Mani Raman. A Mani M cap, Raman R cap, duto bold, Mani Raman. First, relying upon a document, Mani Raman was GM, Mani Raman was GM. Page.
Page is at
It's in the reasoned order, page 101.
101, but
It is recorded in the reasoned order.
101, my lord, where his post was not mentioned, but I have mentioned it in my representation dated 19.
আচ্ছা ঠিক আছে দাঁড়াও কি বললাম 101 তো impugned order.
Impugned order, my lord, I have mentioned this post at
আচ্ছা ঠিক আছে কি বললাম relying upon কেটে দিন লিখুন Mr. Doipan Sengupta, learned counsel, appearing for the petitioner, submits that Sri Mani Raman is one of the
GM finance.
Is the DGM, all cap, DGM bracket finance, whereas the petitioner admittedly has been rendering his service as
Assistant manager finance.
Assistant manager within bracket finance. Poster. The DGM rank is far higher than a assistant manager. The petitioner was directed to render his service in place of Sri Raman without any promotional or other elevation benefit. This according to full stop there. This according to Mr. Sengupta is in violation of the transfer policy. He further relies upon an office order at page 103 to the writ petition and submits that only one or that 4 DGM posts are available at the South Zone, but no assistant manager post is available there. Full stop. Referring to his representation at page, referring to his applications at page 50 and 76 to the petition.
Application for at page 88. 66.
হ্যাঁ ঠিকই না একটা হচ্ছে 90 সরি 90 আর একটা কত 88 referring to the applications submitted by the petitioner at page 88 and 90 to the petition, learned counsel Mr. Sengupta submits that the wife of the petitioner is a scientist working at Kolkata who has her non-transferable employment
The central government.
in the central government, with the central government. He further submits that there are several other employees who have been enjoying their posting at the same place for about 18 and 19 years, continuously. Relying upon these, Mr. Sengupta submits that there is a discrimination on the part of the employer against the petitioner, and the policy, transfer policy, recommending that the request for transfer of an employee at the spouse's place has also not been considered. আগের অর্ডারটা কোথাও বাবা? আগের অর্ডারটা
One thing, my
94
lord, no option was given to me either also as per the policy. They will ask for an option.
Further submits that under the policy, submits that no option was given to the petitioner for choosing a transferred place in terms of the transfer policy. Paragraph. In those circumstances, the instant second writ petition has been filed, challenging the said impugned order, impugned reasoned order dated July 14, 2025, and the transfer, direction for transfer. লিখো। After considering, Mr. Shoroshij Dasgupta's further par contra, submits that the impugned order has been passed strictly following the transfer policy. He further submits that he requests to rely upon the general terms and conditions of employment read with the relevant provisions of the prevailing transfer policy to show that there is no infirmity in the said impugned reasoned order. Paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, this court at the outset reiterates.
Lordship, record one line. There is no, because Lordship said initially that he may continue here. There is no job left for him here. He is required there. That's why the transfer is being made. Kindly.
ষোড়শী যে কি আফটার কনসিডারিং টা বলেছি না, তার আগে আর একটা সেন্টেন্স ঢোকা। Mr. Dasgupta further submits that due to administrative requirement and exigency, the petitioner has been highly required at Bengaluru and he has been transferred there. তারপর কি বলেছি আফটার কনসিডারিং? Reiterates the settled principles of law that transfer is an incidence of service, incidence to the service. Full stop. If there is any administrative exigency, comma, the employer is always at its discretion and is empowered. At its discretion, empowered to transfer its employee from one place to the other, comma, to meet such administrative exigency. The post at which petitioner has been working is a sensitive.
Yes.
Sensitive
post.
Where this administrative exigency may occur at any point of time. Post. না এটা কেটে দিন, এটা এখানে লিখবেন না, দ্য পোস্ট ওয়ার্কিংটা কেটে দিন, একদম কেটে দিন। নেক্সট, however, if there is a settled rules or regulations or for transfer of an employer, it is also to be looked into whether the employer has acted in consonance therewith or not. If it is found that the employer has acted in violation of the transfer policy, comma, if there is any such policy in existence, comma, then of course, comma, this court may interfere with the decision for transfer. Paragraph. After further, upon perusal of the materials on record, it also appears to this court that an opportunity should be given to the respondents to disclose the relevant materials on the basis whereof the transfer has been effected. First. Paragraph. Accordingly, the respondents shall file a report on affidavit on or before.
She gives me 10 days time, my lord.
Give me date.
10 days.
10 days.
আজকে কত ম্যাডাম?
কত সময় থাকে? But by 31st.
August 5.
Very good.
August 5, 2025. Exception on affidavit shall be filed on or before.
In a week.
August 18, 2025. Paragraph. The writ petition shall appear under the heading motion top on August 20, 2025. Paragraph. During pendency of this writ petition, the petitioner shall forthwith join at the transferred place and shall discharge his function and working as an assistant manager within bracket finance.
Transfer place Bengaluru, let it be mentioned. At the transfer place at Bengaluru.
Transferred place at Bengaluru. তারপর কি বললাম? And shall discharge his function as an assistant manager, finance, with all his employment benefits to which he is eligible in accordance with law, without prejudice to his rights and contentions.
Without any breakup, sir, because he has not.
Without prejudice to its rights and contentions. Full stop. Full stop. The petitioner must and should join at Bengaluru within 4 working days from today. 4 working days from today, and the respondent employer shall allow him to work and discharge his function as an assistant manager finance there. Full stop. This is a temporary arrangement. Full stop. The joining of the petitioner at the transferred place at Bengaluru shall abide by the result of this writ petition. Paragraph. The question of continuity of service is kept open and shall be decided at the time of final disposal of this writ petition. Full stop.
The precedence.
Motion top.
This matter should not create any precedence.
This order shall not be treated as a precedence. Full stop. No, but this is an interim order.
Yes. Problem is that
No.
whenever
This is
that
an
order is
interim order.
no right is being created in favor of anyone. So Lordship has
Absolutely. I make it clear. This is an interim order. ওটা লিখবেন না। ওটা ফাইনাল অর্ডারে আমরা দিই আমাদের 142 পাওয়ার so this
kindly clarify. Otherwise, not in the office fees.
It is also made clear that this order shall not create any right or equity in favor of the petitioner, in favor of the either parties, in favor of the either parties.
Then the question of abide by the result of the writ petition.
No. This order, this interim order shall not create any right or equity for the either parties.
Correct, Lordship.
Final decision.
Lordship has kept it open. Continuity of service, Lordship has kept it open.
Of course, because if ultimately he does not succeed, then his continuity will go or at the mercy of the court. Because he has not yet established his right. It is an interim measure, tentative view.
Grateful.
Thank you. Sure. Yeah.
I'll be seeking some time because we have preferred an SLP, my lord, against the order.
Opposing. Mr. Mitra is opposing.
Let him, may I can suggest something, let him conclude. What will give us a month's time for written submissions? If in the meantime matter gets disposed of, Lordship will not deliver, we will not be troubled with the judgment. Otherwise, we'll come back and tell the Lordship.
What happened?
Well, we have filed it, the court reopened on 14th July, Supreme Court. Supreme Court reopened on 14th of July. We have filed it on 17th of July.
What you have filed?
But we have filed an SLP against, my lord, your lordship's order on our application for implement of the.
Why direct?
No, there's no 37 available.
No, 37 is not available. It's really under 36. I passed an order.
So, my lord, kindly gives us, my lord, about 2 weeks time, my lord. I believe, my lord.
No, I'm opposing.
And they are on
why,
case, my lord, I have
tell you
told.
why I'm opposing, my lord. We had filed a caveat.
Yes, sir.
Oh, I'm sorry. We had not filed what? We had filed not a caveat. Now, my lord, what they have done is, my lord, well-known, my lord, method. They have, my lord, put it in defect.
No. Defective SLP.
And my lord, that defect that
With
goes
the
on.
diary number.
Goes on. No, sir, our service says so, lying in defect. So that, my lord, goes on.
With the diary number.
But I do not know, my lord, how to counter this.
No, it's known.
How
There's nothing to
does
counter.
Mr.
These
Sarkar
are all,
know
my
that
lord,
it is
games,
defective?
my lord, litigants play as part of the drill. Nothing new.
No. It may be part of the drill for someone, but not for me.
That I don't. Well, my lord has not filed, my lord. He has not filed the SLP. People
No, it has been
people
filed.
who are
but
filing the SLP are, my lord, handling it, not my lord, not the Advocate General.
The system which the Supreme Court registry follows is that once an SLP is filed, they look into the defect, then they give a report.
Mr. Advocate.
Well, I still
why not been there?
Yes.
You are explaining this.
My lord, may I submit, my lord? Well, only a little bit is left. Little bit left, my lord. Let him conclude. Give us, my lord. Give me 1 month's time. Give me, my lord, 1 month's time. But I'm not saying no.
Mr. Sarkar, to this, I only say, after all, matter has gone up to the Supreme Court. It has been filed. So,
my lord, there is a.
let me
Keep
my hands abeyance for the
my lord, may I just point out, my lord, the Arbitration Act has a wishful thinking. At the time, my lord, given for disposal of a Section 34 application. There's wishful thinking, no doubt. But this matter has been on before Lordship for 18 months. And my lord, look at the statute once for the time limit which is given.
But the order will speak that not for a single time at the instance of the court.
No. But therefore, my lord, the further, my lord, time should not. Lordship been very indulgent, my lord. I have not said no. But my lord, agony must, my lord, our agony must come to an end sometime. Not a litigant's agony, my lord. Counsel agony also.
Mr. Advocate.
Let him, my lord, finish. I'm saying, my lord, let him, my lord, take a month to file written submissions. Within that 1 month, one way or the other, matter will be sorted out. He has only one thing.
I cannot interpret your lordship's order before your lordship. But only thing I can say is that, my lord, your lordship was pleased to come to I would say, a tentative finding that unless your lordship, yes,
forget it.
That's the order is there.
I have delivered my judgment or order, whatever. My hands are clean.
Exactly.
Well, my submission would be, my lord, I leave it to your lordship's discretion. My lord, if I succeed in the SLP, my lord, there would be a direction for the implement of the presiding arbitrator.
Whatever, your prayer will be allowed.
If my prayer is allowed, then, my lord, today's hearing or tomorrow's hearing.
Then, of course, the complexion will be changed.
That's right.
Therefore, let us wait for 2 weeks, my lord. I don't think, I'm not praying for an indefinite.
Kindly record my objection. I never say that.
Yes, definitely.
No, my lord, with respect, my lord. And my lord,
but if it is not heard by 2 weeks,
no, that after, my lord, suppose he comes out at 2 weeks, my lord, the same prayer may be made if it's not been heard.
I'll not make that. I'll not make that.
That, my lord, we all say, my lord, we all say that, but ultimately, my lord, the prayer is always 19th of June, my lord, is the order.
Yes,
no, I'm sorry. No, my lord, I don't come to court. I specially came for this client. Well, look at, my lord, 18 months, my lord, 36 applications pending. 34 has not been heard.
Not been touched.
Not been touched. Then, my lord, that will, of course, take its own time. And, my lord, look at the, my lord, Act, statute, my lord, how much time is given, my lord, for a Section 34 matter. Statute provides for it because arbitration is meant to be more expeditious. 18 months would have gone on a 36 application. We have not yet come to the main matter. And my point, my learned friend had said last time, he will only take a little bit to respond to whatever I had raised. Leave aside the judgment. It's a new point which he heard. That's not been, Lordship has not accepted that point. Let him say what are other points he has. Will reserve judgment, will give me 1 month's time to file written submission. Lordship need not do anything for a month. If something happens in the month, we'll come back to your Lordship. We're not going away anywhere. Let
kindly keep it after
the
2
hearing
weeks,
be concluded. Let the, if want to make submission, conclude the hearing. Give written submissions. We have argued at length.
I leave it to the court.
Acha. So do one thing, please. On the next day, you also come with your written submissions.
Ready.
Because here you will be concluding. 36 is your application.
That's right.
My 36.
You have submitted.
Yes, sir.
Mr.
I was replying to Mr. Sarkar.
So bring your.
I'll say nothing more, Murad. Whatever he has to say, he has to say.
That's right. So on the basis of your argument, Mr. Sarkar's client will prepare the notes. I mean, his junior will prepare the note.
Yes.
So you come on the next day with your note because you have nothing more to develop. Whatever you will submit, you know,
In
or you
reply,
will be knowing by that time.
In reply. Very good.
Ashok. Yes, Mr. Mitra.
No. I'm not saying anything. The Sarkar is here, so my lips are sealed. He once told me that
He can't contradict me anyway. Whatever I've said, he can support.
Once Mr. Jinwala was leading him and he was leading me. So I was getting very enthusiastic.
No, but he can come for the rescue of the court.
I'm sorry, what?
He can come to rescue the court.
Yes, that he can. That is Murad.
That he can.
That. So you must kindly hear him, Murad. Whatever he has to say, I don't mind. No, I don't mind, Murad. Since he's here, kindly hear him.
Mr. Advocate, he can come for the rescue of the
court. So he can come to my rescue also.
I'm neutral.
Come to my rescue.
At least he's saying I'm neutral in this case. Lord, I'm just saying, Lord, that these tricks of the trade, don't tell me. And if I were in his position, I may have played the same trick. So I don't want to say anything.
That's what the court also said. That the court was also this side.
Now I'm coming to the court.
Mr. Kishore Datta, Learned Advocate General for the state, appearing for the award debtor. Award debtor.
He's a privileged position of award debtor.
Yes.
That means that a special leave petition has been preferred from an order dated, from a judgment and order dated June 19, 2025. Passed in the pending section 36 proceeding.
Passed in application made in the pending.
Passed in the application in the pending 36 section 36 proceeding.
Yes.
He prays for 2 weeks time. He prays for an accommodation for 2 weeks. Paragraph. Mr. Shudipto Sarkar, Learned Senior Advocate, along with Mr. Siddhartha Mitra, Learned Senior Advocate, for the award holder, has vehemently opposed the prayer for adjournment. Full stop. After considering the rival submission, this court finds that on the ground of judicial decorum, since a special leave petition has already been filed, the hearing of the main section 36 proceeding can be maybe deferred for some time. Full stop. Tell me a date. আজকে কত? হ্যাঁ? ডেট কোনো দেখিনি। Here on the 22nd, please. Agree? You both of you agree? Yes, Mr. Advocate.
আপনি বলুন। আজকে থেকে 2 সপ্তাহ হচ্ছে আপনার
2 weeks, after 2 weeks. He'll come with the written submission, my lord.
I will record that.
So that, my lord, the matter is closed. Again, my lord, 1 month more for submission, my lord, should not be there.
7th অসুবিধা হবে তো?
No, either Tuesday or Thursday.
Yes, 7th is a Thursday.
7th August. Thursday আমার কিছু আছে দেখুন তো।
You just file the note. It'll take.
No,
Note I will record.
7th August.
7th August.
না 7th অগস্ট হলে তো 1 সপ্তাহ পাচ্ছে।
না, আজকে তো 22 তারিখ।
2 সপ্তাহ হচ্ছে তো, more than 2 weeks.
11th অগস্ট,
22nd July.
12th অগস্ট যদি অসুবিধা না থাকে আপনার।
12th August
কি বার সেটা?
7 তারিখের জায়গায় 12 তারিখ বলছে। Tuesday. Lordship only takes on Tuesday and Thursday. So 12th August, 2 p.m.
August 12th, 2025. Under the heading, কিসে আসে?
Specially assigned.
Under the heading application within bracket specially assigned, marked at 2 p.m. Marked at 2 p.m. Paragraph. Learned Advocate General has assured this court that he shall also file the written notes on argument on the same day.
Both may file.
Yes.
They may also prepare their notes.
Yes. No further time need be given for that.
Parties let him file, then you file.
Well,
but not a response to my written notes.
No.
No. In response to your argument.
Yes, argument.
Argument. The note will be with the court.
That's right.
He will know. Has assured this court that
his assurance is worth its weight in gold. Please, I say so. It's worth its weight in gold.
More so 21st of July. It should be more strength now. 21st of July, more strength now. But assures the court that no further time will be
on the same day. Full stop.
And no further time will be sought for.
On this ground. And no further time shall be sought
Otherwise,
for.
there's no point in our keeping on coming.
Full stop. Thereafter, the award holder shall file its written notes.
Any short time, your lordship gives, which is new arguments.
Your lordship already knows what we've argued. So if you're putting something in the note which is not there, your lordship will take. That risk I don't take.
Full stop.
No.
The judges who had a practice in this side, I don't take.
Quite happy.
Heading fitting the
in case I join online, they'll be here.
Of course, why not? I know, and I never disallow anybody.
I should tell you, lordship,
online. If the technical glitches are there, what to do?
No, that is different.
Thank you, sir. Thank you.
I'm grateful.
We are grateful. Yes, Mr. Mitro.
For the petition in this matter, my lord. This is also another matter of MMCC, my lord. In the last occasion, my learned friend, my lord, offered that ECL is agreeable to pay the MMCC from the date of application. Though my prayer is from the date of death with interest, but since, my lord, they are offering, my lord, I don't want to go, my lord, for any dispute, and I have also taken instruction. But only one thing, my lord, the time limit may kindly be given for 1 month, my lord, because 1 month, my lord, because they are agreed, my lord, since long.
Your Lordship,
1 month, my lord.
There again an extension will be sought for.
Kindly, my lord.
Let me allow a reasonable time if they don't, so that you can come up with contempt.
Your Lordship, the date of
And my lord,
application shall be
and
5th of
one thing, my lord, time limit as may be fixed by your lordships. If, my lord, they do not, my lord, pay by that time, even after their agreement,
Interest.
my lord, kindly that
That I have kept in my mind.
my lord.
Your Lordship, the date of application shall be 5th of January.
Wait, madam.
This is the instruction.
Wait. Ashu. The petitioner being the Mr. Partha Ghosh, for learned advocate for the petitioner, MS
Amrita Pandey.
Pandey, learned counsel, appears for
Respondents, all respondents.
ECL. Full stop. The petitioner being the widow of the deceased employee of ECL claims the monetary compensation bracket MMCC, comma, since under the policy of the coal company, since the employee died during his employment tenure while in service. Employment tenure. Paragraph. In all fairness, ECL has agreed to pay the MMCC claim, MMCC component in accordance with law to the petitioner, but the interest shall be paid, along with interest at the rate of 6%.
Your Lordship, interest we have not agreed. My learned senior has also said that he's waiving the interest, because I have written instructions that primarily he had agreed only from date of application, and if within 2 months we don't pay, then his prayer is that interest may be.
Okay. কি বললাম? Along with from the date of the application being
5th of January 2011, page 37, P4.
January 5, 2011. Annexure
P4 37.
P4 at page 37 to the writ petition. Paragraph. Mr. Partha Ghosh, learned counsel, appearing for the petitioner, upon instruction from his client submits. On instruction from his client submits. The petitioner is agreeable for the said proposal of the ECL. Paragraph. In view of the above, the MMCC compensation payable to the petitioner in accordance with law shall be paid by the appropriate authority of the ECL positively within a period of 2 months. 2 months kotata bold, T capital, M capital, from the date of communication of this order. Full stop. Paragraph. In default, ECL shall pay interest at the rate of 6% per annum from the date of the said application until the actual payment shall be made to the petitioner. Paragraph. Since affidavits are not called for, what is that?
Will written instruction be kept with the record?
My instructions also.
Both the written instructions.
Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. The instructions received by the respective learned counsel from their clients placed before this court are taken on record. Good. Thank you.
Sincerely obliged.
Well, for the petition in this matter, my lord, if you lordships kindly see the last order, they are agreeable to, my lord, provide the employment. And my lord, they have sought for time 1 month, my lord, way back in possibly in January. If you lordships kindly see the last order passed by the coordinated bench. Hmm? 25th February 2025.
Yes.
Lord, in respect to this matter, my lord, the first component, my lord, as far as, my lord, the employment is concerned, the appointment, my lord, we have asked the respondent as advocates, my lord, to expedite. I would humbly pray for a week's time only, my lord, so that a decision could be made in this regard.
Ajay Kivar,
Today is Tuesday, my lord.
come on Thursday.
May it be next week, anytime next week. my lord.
Thursday.
Thursday
This
week.
Thursday.
This Thursday week, my lord, if it can be, or Tuesday, my lord, next Tuesday.
The last order dated February 25, 2025, passed by the coordinate bench, passed by a coordinate bench, speaks for itself. Mr. Shaunak Sengupta, learned advocate, appearing for ECL,
Hello.
comma, on instruction from his client, comma, submits that the necessary appointment letter shall be issued.
My lord. Necessary decision, my lord, will be made within the next week. Whether appointment letter or not, my lord, I cannot say that on without instruction.
The necessary decision shall be taken and communicated to this court within a week. In the light of the said order dated February 25, 2025. Paragraph, accordingly, the appropriate authority of the ECL shall file a report intimating, communicating its decision before disclosing its decision with relevant materials before this court on the next day.
In default, There are my lord, another one order.
There
That
is a
if
second portion of the
second
order,
part,
my lord.
if in
And
case
it
my lord
is-
they do not provide
MMCC.
MMCC from the date of death with interest.
I,
Quickly.
My lord,
next
that
day, my lord, I'll
That
start.
what instruction they will take. It is the automatic.
my lord, kindly
What about your Bauri?
yes, my body,
That's
my lord.
good stuff.
I'll give the tabulation, my lord, next week when I come.
You bring whatever you want to disclose in the light. That's why I said in the light of this order.
Because there was a direction for quantification of the
I
amount.
said in the light of
Sure.
this order.
You have that.
That already speak for itself, my lord.
The writ petition shall appear under the heading কি আছে? Court application on আজকে কত? July 31, 2025. Mayavadi has been reported.
I have not my lord, checked. Actually, my lord, nowadays, my lordship knows the physical books are not being printed. Only we are basing only the online SCC, my lord.
SCC, AIR, all those.
SCC, yeah, my lord. This is the difficult one. CHN, those days, my lord, we used to see the CHN and CLJ, my lord.
Yes.
On the interest on delayed payment of the provident fund.
I have got the responded, my lordship.
I made the necessary corrections.
Show it to.
Yes, I have shown. On the date of superannuation, date of payment, and the amount I have changed.
If any further mentioning for correction, I will not entertain. Matter ends. Why should not I rely upon all of you
Get put your
in this type of order?
I am appearing on behalf of state respondents.
The benefit once given has been sought to be withdrawn. What was granted in 2015 was a.
Give me an outline.
Before Mr. Mujumdar starts, well, I'll just take only half a minute time. Well, this is the main issue.
For?
I am for the West Bengal, the WB SIDCL, the main
employer.
SIDCL, Small Scale Industrial Development Corporation. Well, here the issue is, they are the employees under it, under the West Bengal SIDCL. So issue is, my lord, that whether they are entitled to get the benefits under the ROPA, because they are admittedly a contractual employees. And even whether they are entitled to that extent, whether they are entitled to get the benefit equivalent to that. So, my lord,
that they can claim in terms of ROPA.
ROPA. And, my lord, the fact remains, previously, my lord, the equivalent.
Hey, এটা একটু কমিয়ে দাও, এক করে।
Equivalent to ROPA. That
benefit were granted.
Yes, granted. But
that's right. That is why they are claiming.
Yes, subsequently, my lord, the writ petition and there is an order of injunction. My lord, kindly see the order of stay regarding whatever they used to get, they will get the same thing, benefit. Till
no ROPA.
No ROPA. My lord, kindly see that. First, my lord, the order, then, my lord, kindly, and my lord, not only that, because I am the parent department is the government, MSME. So whatever decision, if that MSME says yes, we can do and in that regard, there is an order to that respect that the government has to file a report. What steps you have taken?
You are for this state.
Yes, my lord, there is
That
a
is the
direction.
case.
I am filing this report.
In the shortest possible.
So give him a copy.
I'm not. We were we are employees of West Bengal small
You
industries.
go consider the report and come back.
We have, we know the stand, we can, in course of the hearing, we can deal with that. Oh, acha, judges.
আমিও পাইনি দেখি আমাকে দে
But this is probably not, may I just put my case in a very short compass. But we are employees of West Bengal State Industries Development Corporation Limited, an Article 12 authority appointed as company secretary, assistant engineer,
my lord, they wish to suppose, my lord, if they are not, we are happy with this. So far the order is concerned, I think there is some order that he is not entitled to that contractual employees.
Have they challenged that?
That's a report.
No, it's a report.
There is a direction to
On
file
the
a
basis
report.
of the honorable court's order.
So I will read that report.
Yes, unless if they want to file an exception, they can.
So they chose not to.
No,
How
not
does it matter to you?
We were appointed through advertisement, interview, and then
Ashud. Nikunto, Mr. Shoumo Mujumdar, learned senior advocate, appears for the petitioners. Mr. Sushobhan Sengupta.
Yes.
Mr. Sushobhan Sengupta, learned
representing the
additional government pleader, appears for respondent numbers 224. 224. আচ্ছা, কোথাও কিছু বুঝতে অসুবিধা হলে না সঙ্গে সঙ্গে আমি থামিয়ে জিজ্ঞেস করবেন যতবার খুশি, কিন্তু এই ডট ডট বা ইয়ে বাদ দিয়ে যাবেন না। MS
Tapati Samanta.
সামন্ত, learned advocate,
Led by Mr. Shishanu Bandha, appearing on behalf of the
led by
respondent number.
Mr. Shishanno Bandyopadhyay, learned senior standing counsel for the state, appears for
Respondent number 1.
respondent number 1.
That is the MSMED. Government.
Pursuant to the direction of the coordinate bench, paragraph, it's a paragraph, dated April 18, 2024, the respondent number 1 files a report today.
Today, the same was handed over to us.
In court, comma, the same is taken on record, full stop. Copies have been served upon both Mr. Mujumdar, learned senior advocate, senior advocate, Mr. Shomu Mujumdar, and Mr. Sushobhan Sengupta, learned additional government pleader. Full stop. Yes. Oh, paragraph. On perusal of the report, comma, learned senior advocate Mr. Mujumdar submits that the petitioner shall not file any exception thereto and shall proceed on the basis of the existing record.
I'm not.
Wait. I'm not that fast.
I'll just give a brief background of the without opening the papers.
Growing old. Not that fast. I'm a young man.
Your lordship has got a fresh insight.
The gentleman has.
And my lord is already doing yoga. Isn't it, my lord? Yes, I heard it. I have heard. For inner strength.
Some desire to retain age, some let it go as it is.
Taking advantage that I cannot speak. One second. বসে পড়ুন
হেমন্ত কুমার দাস।
Yes, sir.
I heard your lordship had the privilege of going through a Privy Council citation in the first half.
Yes, yes. And it was so extensive, a hearing.
Extensive.
And very good to see. Yes.
Now, Lord, they are employees of this organization, appointed through a regular process, but on contractual terms.
Regular process means advertisement.
Advertisement, interview, appointed, but on contractual terms. My Lord, some were appointed in pay scale of Rupa 2009, some on consolidated pay, and some on remuneration for contractual employees. Now, in 2010 and 2012,
are you carrying any list of dates?
I just indicate the page numbers. I'll put it in the form of. There were board meetings conferring certain benefits to the employees.
You are an employee of
West Bengal Small Industries Development Corporation Limited.
It's a PSU.
It's a Government of West Bengal.
Exhaustive list
Government of West Bengal undertaking.
A PSU, public sector undertaking.
Normally, this term is
That's why I mean to say that it's a government of state, government company, wholly owned. No, it's my mistake in expression. I thought it was. Achha, do you have a list of dates in front of the writ petition? Will it help you?
Yes, that's an exhaustive one, but I will make it shorter for the purpose of.
Take me through the dates which are important. Yes, first you give me a nutshell. It's a hearing matter. Take your time, give me in a nutshell.
Through board meetings, certain benefits were conferred on these employees in terms of pay.
After employment.
After appointment.
After
appointment. Some were born in the ROPA 2009 pay scale, some engaged on contractual terms. Now, these board meetings in 2010 and 12 had conferred them certain benefits in terms of pay.
In terms of?
Pay.
In terms of pay.
Pay. But I just read 2 pages. Your Lordship may not have to look into this page for the time being. It was decided that the consolidated salary, to review the consolidated remuneration paid to the contractual employees of the corporation. This was the agenda item. Board noted that following the adoption of the 5th Pay Commission recommendation for the corporation's employee, there is a wide gulf in the remuneration between the officials of the corporation and its contractual employees, resulting in difficulties in holding back talent in the corporation. The corporation has engaged the following category of employees on contractual basis. Company secretary, there are 5 categories. I restrict myself to the 3 categories who are concerned in the writ petition. Company secretary, assistant engineer, and sub-assistant engineer. After detailed deliberations, the board decided that for the emoluments of the company secretary be indexed with the executive engineer, as the company secretary is a very senior position in the corporation. As regards the computer personnel, it was decided that so and so. I am not concerned with that. In the case of Srimati Bandana Saha, who joined the corporation,
page
83, 82 and 83.
Is the board resolution.
Board resolution. It begins at 77. Relevant portions are at 82, 83 and 85.
Page 87.
82. It begins at 77.
Achha, so one by one, sir. Board resolution dated 5th February.
5th February 2010.
Yes.
Last page at 78. Please come to the first resolution at page 78. Corporation has The heading is
has engaged.
Just above that line, to review the consolidated remuneration paid to.
Yes.
The corporation has engaged several category of employees on contractual basis. These are the categories are mentioned. There are three of the
You are for the which
company
category?
secretary, assistant engineer, and sub-assistant engineer. 1, 3, and 4.
Very well.
It may be pointed out that with the adoption of the Pay Commission's recommendation, the gulf in remuneration between officials of the corporation and its contractual employees has increased tremendously. This is resulting in difficulty in holding back talent in the corporation. While the issue of contractual sub-assistant engineers has already been referred to in addendum number 30919, the other aforementioned cases are also required to be addressed. In this connection, it may also be mentioned that the employees can be grouped into 3 categories: retired government employees, retired corporation employees, others. It is proposed that for the first category employees involving serial numbers 2, 3, and 5. So 3 and 5 are one of them is.
You are not.
I am not.
5 you are not.
I am not. Government
3 you are.
3 I am.
Yes.
The government system of offering last pay drawn sanctioned pension may be adopted, not commuted, non-commuted. Second category of employees involving 1 officer in 3 above, that is assistant engineer. The government system of offering last pay drawn sanctioned pension may be used as the basis for calculating emoluments. Please see the choice of the expression. Emoluments.
Second category of employees involving 1 officer in 3 above. What does it mean?
Assistant engineer.
Acha. 3 above.
The government system of offering last pay drawn dash sanctioned pension non-commuted may be used as the basis for calculating emoluments. So that is indexed for the purpose of fixing emoluments.
So last pay drawn plus
by a government officer in the department is indexed for the purpose of fixing the emoluments of the corporation's employees. Not same.
First category, second category, he has not concerned.
Third category of employees, which involves 3 persons, they may be further subgrouped into company secretary and computer personnel. It is proposed that the emoluments of the company secretary may be indexed with the executive engineer, as the company secretary is a very senior position in the corporation. For the computer personnel, we are not on Tapon Rai. Please see the next one. Srimati Bandana Saha, information and system analyst, has joined this corporation on 9th August 2007 at a consolidated remuneration of rupees 6,500 only per month with effect from 9th August 2007. She is now drawing emoluments of rupees 7,350 with effect from 9/8/2009. Srimati Saha is a science graduate with an advanced diploma in IT from IGNOU, as well as an advanced diploma in computer applications from IGNOU. While Sri Roy was recruited through an interview process, Srimati Saha was recruited through interview after newspaper advertisement. It may be appreciated that the salary offered for a block informative, not on block informative officer. It may be pointed out that the 2 employees are doing the third bullet point on that page.
It may be
pointed out that the 2 employees are doing a yeoman's job in supporting the various computer-based applications in the corporation. It is thus proposed that emoluments for Srimati Saha may be fixed at the beginning of the aforementioned grade with DA at the current rates, and for Sri Roy it may be fixed with 9 increments, taking into account the fact.
Wait. It is thus proposed
that emoluments for Srimati Saha may be fixed at the beginning of the aforementioned grade, so lowest stage of the grade.
Means,
say 9,300 to 30,500 is a pay scale. This pay scale, your lordship knows, after that 6th pay commission, there were several grades and grade pay. Now it is pay band. Now each pay band may have 3 scales. say PB3 has 3 pay scales, one from 9,000 to 20,000, 9,500 to 25,000. Now, each pay scale or these scales of pay may have different grades. Grade pay is 4,200, 4,600, 4,800, 5,400, it goes on like that. So, what was proposed was, considering these situations, the recital in this, the purpose for this memorandum, this board resolution, it was proposed that whatever may be her seniority, she would be placed at the beginning or the initial stage of the pay. She could have been placed at, say, 10,500, but disregarding her placement in the pay scale, it was decided that without granting her increments, she may be placed at the initial stage or starting point of the pay scale. Say 9,500 to 20,000 is the pay scale. 9,500 is the starting point. I had put in 3 years of service. My pay would not have been 9,500, it would have been, say, 12,500. The decision is no, don't give her this position, or don't fix her pay at 12,500. Fix her at 9,500, initial stage of the pay scale.
So 9,000 will continue.
That is her pay. Thereafter, you give her DA or whatever emoluments.
Yes. So 9,000 will never rise.
It may, the annual increment will be granted. Annual increment may be granted.
Annual increment may be granted. But that scale will not apply. Not apply.
So, and that's not exactly in tune with the.
You are saying that to Mr. Sushobhan Sengupta, you are given the scale. Right. But another one, you have not given the scale. You said 9,500 is the constant.
No. I am given the scale, but at the lowest stage.
That's right. Lowest stage. It will not rise.
It will rise with increment, annual increment.
It will rise.
In the scale, right?
Then what is the difference?
Not I don't get fixed in the scale of pay at the appropriate stage. I ought to be fixed at 12,500. So my salary could have been, say, 25,000. But I am placed at 9,000. So my salary is 20,000. So I start from a lap behind. It is thus proposed that emoluments for, please see the user of the expression, it's not fixation of pay. The emoluments for Srimati Shaha may be fixed at the beginning of the aforementioned grade with DA at the current rates. And for Sri Roy,
so DA is getting merged.
DA is with the appropriate stage of the scale of pay. DA is a fixed DA. Say the government of West Bengal today is paying 20%, say 13% DA. So 13% DA on 9,500 will be less than 13% DA on 12,500. So I get less DA, I get less basic pay, I get less house rent allowance, I get less of every other heads of pay. And for Sri Roy, it may be fixed with 9 increments, taking into account the fact that he joined 9 years earlier. I am not representing Sri Roy.
So he joins to, both persons joins on the same day.
No, one has joined earlier.
Hello?
After, please see the next paragraph. After initial indexation with effect from 1/1/2009, after taking into account the DA rates prevailing, the emoluments may be frozen for 3 years.
Yes.
Effect may also be given to all these emoluments from 1/1/2009. So that's
yes.
So that was the rationale for classification. Whether this is a valid classification in the anvil of Article 14 or not, that is to be tested by your lordship. since they are seeking to withdraw this after a period of 9 years?
You then first show me in case of contractual employees, violation of 14 can be done. Show the law.
I'll come to the law. Just senior, please permit me to take to the.
If I find it is not so, because I will also give my logic, then I need not, I don't require to go into the merits.
No, Article 14 not vis-a-vis regular employees, but Article 14 in the anvil of arbitrariness.
Article 14, whether can be claimed by a contractual employee simpliciter.
Okay, that is settled. Not,
why I tell you,
no, I'll cite their judgment.
Why I tell you, it's a contract between, let's say, you and I. For whatever reason you want me to clean your car against a remuneration of 1,000. Full stop. No further, no less. While I do the same work for Mr. Sengupta, he pays 1,500 under a different contract.
When he lordship, I didn't get that.
Suppose
there is a 1,000 rupees contractual rate. That's right.
Between you and your employee. That employee or wash your car against 1,000. Same employee has another contract with Mr. Sushoman Sengupta, who is less miser than you, who pays 1,500.
Or maybe richer.
1,500 to the same employer.
Article 14 does not apply if the employer changes. Not, I give another example. There are two brothers residing in the same house, one residing on the ground floor, the other on the first floor. They go to the same office in the same building, one on the ground floor, one on the second floor. They travel by the same bus. One is employed by the central government, the other by the state government. One gets 73% DA, the other gets 13% DA.
Yes.
So Article 14 does not apply if the employer changes.
Very well, the same employer. Same employer. Let's take a situation. Same employer. Employer is one, employees are two. Right? First employee engaged for washing the car 1,000. Second employee employed for washing the car at 1,500. Violation in a contractual employment.
But if other things remaining same.
Show me that judgment.
I'll just, I don't know why unfortunately
Only I am interrupting, Ballard. Before that, whatever submission he has to make within the four corners of his averment. Where is that? Kindly see what is his averment. Let him.
First, I am absolutely on the first principles of law.
First principles only when he could have averred this, whatever submission is he's now making.
So
there is no, yes.
Let him, you place the press.
Yes. Let him disclose that he has stated whatever submission he is making right now, he has stated.
Place the prayer.
Yes. Well, kindly see. Well, it starts with page 5.
No, it starts with page 29.
Oh, yeah, prayer. Yes. Yeah, I just, because, yes. Declaration that the petitioner is entitled to pay protection under DOPA Rules 2020, which he is not entitled to get. Writ of malafide.
Entitled to, not entitled to that.
Yes. Yes, forget.
Show me the prayer.
Now, rate in the matter commanding the respiratory subordinate race in recall. Kindly see. Set aside 360th meeting board held on 13/9/23 and meeting of Human Resources 99 being annexed 15. This is his case. These are statutory same.
And the grounds for this is violation of 14.
Yes.
That's his case.
Where is that?
Hurry. For that, he has to plead.
No, my lord. Yes, there is no such pleading. Whatever submission he just.
Is it required, sir? Now, if he says that the board meeting.
No, what as per his abandonment, why he has sought for this prayer? Because the board in their resolution, held that they are entitled. But subsequently, it was altered, set aside. That is the challenge here. So far, this
set aside or altered by the board itself.
For the board itself, saying that I have got no authority.
That's right. That's why
that is why not that section 14 violation. Kindly consider. Yes, recall. Set aside.
Next prayer.
Yes.
Restore the previous order.
Previous order. That means that order. That
which
order
set aside.
Which was set aside by the board.
Correct.
Subsequently. That
he is saying that setting aside of that second order, or rather original order, is in violation of 14. That's his case.
Violation of, but whatever submission he is making, that is not violation. Yes.
You take your seat, sir. You will get your turn. Yes, sir.
Just read that particular paragraph from the Supreme Court judgment.
Judgment ka do.
May I just read the 2017 citation?
2017? And you crystallize the point first?
Not contractual, casual, or whatever temporary employees, if they are rendering the same job, although not equal with the regular employees, they are entitled to the initial stage of the scale of pay.
Show me, yes, give me the citation.
2017, 1 SCC page 148.
That is, I think.
I can't hear you, sir. I can't hear you.
17, 1 SCC,
148.
148.
Paragraph?
Paragraph 48 and 49 on
page number
148.
Yes.
May I just read that? The defense taken was that they were not regular employees and they were temporary and casual employees, therefore not entitled to an equal pay. We are of the considered view that in paragraph 44 extracted above, that is in Uma Devi's case, Constitution bench clearly distinguish the issues of pay parity and regularization in service. It was held that on the issue of pay parity, the concept of quote-unquote equality would be applicable, as had indeed been applied by the court in various decisions. But the principle of quote-unquote equality could not be invoked for absorbing temporary employees in government service, or for making temporary employees regular or permanent. So in this judgment, not apropos Uma Devi's views, not the court was making or explaining Uma Devi to strike a balance between regularization of temporary employees vis-a-vis their right to pay. All the observations made in the above extracted paragraphs relate to the subject of regularization or permanence and not to the principle of equal pay for equal work, once again within quotes. As we have already noticed above, the Constitution bench unambiguously held that on the issue of pay parity, the High Court ought to have directed that the daily wage workers be paid wages equal to the salary at the lowest grade of their cadre. This deficiency was made good by making such a direction. And that was page 78. Put them at the lowest stage of the scale.
And you are claiming the same. Next.
But a conscious decision objectively taken for the benefit of the organization to retain these employees in service so that the corporation's work does not suffer. Now, it comes the next board decision at page 82.
Dated?
Begins at 80, but the relevant portion is at 82.
Dated?
It is dated 5th February 2010.
Yes, that was you were placing 77.
That was the previous one.
Acha, oh, same day.
That one, yes.
Same day?
Same day.
82. Oh, next resolution. Yes.
No, Lordship, I'm sorry. Lordship, I placed that. Lordship, may straight come to 85, the next board meeting. 29 June 2012. Now, that was a proposal at 78. Page 80 is the resolution taken, same language. I need not trouble your Lordship with that. Then please come to 85. That's the next board resolution. Approval, it has a heading, agenda item number 25-319. Approval of pay scale fixation in different cadres employed on contract basis or on work charge and enhancement of dearness allowance applicable to these categories. Please see. Pay fixation in different cadres employed on contract basis or on work charge.
Pay scale fixation in different cadres.
Employed on contract basis or on work charge. Even on work charge basis. Not that's project employees.
And enhancement.
And enhancement of DA applicable to those categories. The second paragraph, first paragraph, sub-assistant engineers engaged on contract basis are allowed emoluments pay in pay band 3. Now, not in 2012, the pay band concept has come. Plus grade pay, plus prevailing DA, plus HRA at the rate of 15% in the scale of 7,100 to 37,600 with grade pay of 3,900. As per resolution taken in the 309th meeting of the Board of Directors. Whereas the sub-assistant engineers on work charge basis are allowed the emoluments which consist pay in the pay band 3, plus grade pay, plus prevailing DA, plus HRA at the rate of 15%, plus medical allowance at the rate of rupees 300 in the scale of 7,100 to 37,600, plus grade pay rupees 3,900 as per resolution taken in 313th meeting of the Board of Directors. Hence, all the components as stated in the salary structure of the sub-assistant engineers on work charge. Not work charge, your Lordships knows these are like project employees, no work, no pay basis. May also be taken into account for the purpose of computation of total emoluments of the sub-assistant engineers. So what is conceptualized or thought of is total emoluments. And their DA will be enhanced as and when the DA of all corporation staff is revised upwardly as per government order. So pay is like the work charged employees, DA as per the regular employees, as and when the government will notify. B, in case of system analyst, programmer and information and system analyst, the emoluments will be as follows. Pay in pay band 3 plus grade pay plus prevailing DA plus HRA at the rate of 15% in the scale of same grade pay of so and so as per resolution adopted in the 309th meeting of the board. It was also decided in the said board meeting that their DA would be revised after 3 years. Therefore, to avoid anomalies in the fixation of pay in case of all contractual or work charge employees. So what was sought to be eradicated was the difference between work charge and contractual employees. All the components as stated in case of sub-assistant engineers in the pay of the system analyst and programmer and information and system analyst may be fixed in the pay band of so and so, may be taken into account. DA may be enhanced as and when the DA of this corporation staff is revised upwardly as per government order. So that's the difference between the regular employees of the corporation who are born in ROPA vis-a-vis these employees who are contractually appointed, brought in the born in the pay scale, lowest stage, 3 years freezing for a particular category as per government order for a different category, but they should be same as the work charged employees, like project employees.
But it's a policy decision.
Policy decision. And what, why this was taken, not the recital is, we want to retain them for the benefit of the organization because of their expertise.
You are saying that the policy decision taken is arbitrary.
Is
That's-
not, yes, no, subsequent reversion is arbitrary.
Right. Subsequent is the existing policy decision, which is arbitrary. You cite me the law. First, you have to give me the copy of this judgment, right? On the next day. Then you give me a judgment that contractual employee vis-a-vis permanent employee. In a like situation, it's done.
Is the
That's the law.
They were claiming benefits of regular employees. Court said, no, you don't get equal pay like the regular employees, but this disparity should be eradicated by placing you in the lowest stage of the scale of pay.
So, whatever way, court has compensated, equated.
Otherwise, not.
I need to read that.
But I gave them somehow not this soft copy system is more prevalent. I told them on the belief that this will be brought in court.
Oh, we'll get it in my tab, but still.
No, this is not underlining and all these things is more easier and it strikes. Not when one reads and underlines, it strikes.
Old school. Yes.
Now, Lord, please see the page 109 in the second volume, probably.
আমার ভলিউম আছে? What is that?
Now, this is an office order issued by the employer in 2015. The board of directors of this corporation in its 332nd meeting held on 29th.
Wait. 109.
109A is a better legible copy.
What is that, sir?
But this is an office order of the corporation.
Oh, by which it was reversed.
This is a further adoption of the government order.
Wait.
Which grants annual increments.
Yes.
The board of directors of this corporation in its 32nd meeting held on 29 December 2014 has adopted the policy for fixation of remuneration of the contractual employees of this corporation. Accordingly, the remuneration of the contractual employees who are enjoying a pay scale is hereby fixed as on 1/7/2014 in the following manner. But this is an order of 2015. The basic pay of these contractual employees as on 1/7/2014 are to be fixed up by allowing notional benefit of annual increments from the date of their joining in their corresponding pay scales. After fixation of their basic pay on 1/7/2014, they will get annual increment at the rate of 3% of their band pay, that is, basic pay plus grade pay, on 1st July each year, and added to their prevailing basic pay after rounding off to the next multiples of rupees 10. Now, that is the system of pay fixation. But if it comes to say 3,959.75, then it is rounded up to 3,960. Fixation formula: basic pay as on 1/7/2014, initial basic pay, that's say 6,500, in the corresponding pay scale as on the date of joining, plus notional benefit of annual increments. I don't get the actual, but I am notionally treated to have earned increments for the years they have rendered service. Service rendered for a time period of 6 months or more prior to 1st July shall be considered as one completed year of service for allowing annual increment. In future, the contractual employees who will join in the corporation in a pay scale will be entitled to get annual increment in the similar manner on 1st July each year if they are in service. Their basic pay will be refixed as and when any revision or modification in their corresponding equivalent pay scales are made. No arrear will be given to these contractual employees. Financial benefit may be allowed with effect from 1/7/2014. So what is additionally granted is annual increment.
To the permanent employee.
To the contractual.
Acha.
As on 1/7/2014. Now please take page 112.
Volume, this is volume?
Second volume.
2. এটা একটা আপনি সাদা ফাইলে পিটিশনার আজকের তারিখ আপনাদের আলমারিও আলাদা অ্যাপিলেট সাইড অরিজিনাল সাইড এটা অ্যাপিলেট সাইড আলমারি ওটা অরিজিনাল সাইড Yes.
In this department number so and so dated 16 September 2011, it was decided to allow appropriate emolument security of tenure.
আলমারিও আলাদা অ্যাপিলেট সাইড অরিজিনাল সাইড হ্যাঁ Yes.
It was decided to allow appropriate emoluments security of tenure and certain
where?
Page 112.
Yes, yes.
In this department number so and so of 2011, it was decided to allow appropriate emoluments, security of tenure, and certain terminal benefits to the casual or daily rated contractual workers subject to fulfillment of conditions therein. The matter regarding improvement of monthly remuneration, annual increase, medical facility, leave and other benefits, as well as review of the conditions of engagement were under active consideration of the government for some time past. Now, after careful consideration of the matter, the governor has been pleased to decide and revise the benefits as follows. All contractual, casual or daily rated workers shall continue to be in engagement up to the age of 60 years. Engagement of contractual, casual or daily rated worker shall not be terminated except as prescribed in the aforementioned memo. Consolidated monthly remuneration of contractual, casual or daily rated workers will be as follows. So less than 5 years present 7,000, proposed is 10,000. It goes on like that. Please come to serial number 3, III. Enhancement of remuneration 3% in every year. Terminal benefit on attaining the age of 60 years 2 lakhs. Medical benefit, they were brought under an insurance coverage of 1 lakh.
This is for the contractual.
Contractual, casual, daily rated all.
Where? The memorandum?
In this department number so and so, it was decided to allow appropriate emoluments or security of tenure and certain terminal benefits to the casual, daily rated, contractual workers.
So you are happy with this?
3% annual increment, fixed retainal benefit, then other things.
But you are happy with it.
I had been granted this. This was already implemented for us.
That's right. So these are the contractual terms changed from time to time.
Yes.
And now you are happy with this. So what makes you unhappy?
But it's withdrawal of the board resolution.
Show me that document.
That it's at page 166. Probably in the 3rd volume. Volume 2.
Page?
Page 166.
One zero six.
166. 166.
This is the
a board resolution of
13th
13th
September.
September 23.
Wait. Yes, sir. Place the relevant portion.
At 168.
Which agenda you are hit by?
At 168.
Yes.
To note the recommendations of the HR committee.
Acha. Item number 8.
In the 366th meeting.
At 168. Yes. Yes.
The BOD noted that the recommendations of the HR committee and were of the view that it will be unfair to increase the salaries of only 2 contractual employees while other contractual employees would wait for the approval of the finance department for getting their salaries revised. The BOD requested the HR committee to take a suitable decision in revision of salaries of all contractual employees without any deprivation of their legitimate dues. After discussion, the BOD decided to induct so and so of the company in the HR committee and ordered for convening a meeting of the said committee on 19 September 23 at 12 noon and empowered the committee for finalization of revision of salaries of all contractual employees of WBSIDCL. The HR committee along with the new directors have met on 19th and the minutes have been annexed at the end. Please come to 176 now.
One?
176.
Yes. What is that?
The chairman of the committee.
Minutes
of the meeting.
Same date.
Same date.
This is volume
2.
2 or 3? 2. One second. Yes.
The chairman of the committee invited all the members. At the outset, the HR committee was briefed about the issues or agenda. SIDCL has not been recruited regular employment since 1999, except in case of die in harness. This has created acute shortage of staff and hence several employees were directly engaged on contractual basis. Presently, the contractual employees are working both at the field offices and also at the head office. The contractual employees contribute significantly to the day-to-day activities of the corporation. WBSI DCL management has been receiving multiple prayers or requests from the contractual employees for pay revision, leaves, security of tenure, regularization, etc. In the past, the board has taken a piecemeal approach. Further, it was noted that the management has sent the proposal for regularization of few contractual employees to the department. Director so-and-so had informed the members that a high-power committee is being formed by the government of West Bengal to address various identical issues and demand of contractual employees all over the state. Considering all the above, the committee noted that the mandate before it is to remove the disparities among the contractual employees and provide a feasible long-term solution to the contractual employees' grievances.
Wait. So what did the high power committee do?
But the high power committee of the government is being formed.
No. It is under the BOD, Board of Directors of the company.
No, you said
human. My lord, what he is reading, my lord, the kindly
had
see
informed the members
of
that
the meeting of the Human Resources Committee of the WBSIDC. So it was appointed that this committee was appointed at the instance of the WBSIDC.
No. Director has informed the members that a high power committee is being formed by government of West Bengal to address various identical issues and demand of
My lord, the Human Resources Committee of who has taken the resolution? Kindly see.
Oh my God, I am not on.
No, kindly come.
Yes.
Mr. Such and Such had informed the members that a high power committee is being formed by government of West Bengal
Yes.
to
High power
address the various incidental issues.
Yes. Said orders and resolution have created disparities among the contractual employees. Some of the contractors were getting pay equivalent to ROPA 2000 and while others were on considered pay. Further, some were allowed security of tenures and others did not. Members of the committee director WBSIDCL unanimously agreed that WBSI ROPA 20 cannot be awarded to contractors of any category.
We are on a different page. I am on page 176.
176. Yes, last part because I am showing the relevant part.
No.
Yes.
And order was asking a different question.
Management has been resolved. My lord is going.
No, what happened to this high power committee?
My lord had informed the members. Sri Joyprakash Majumdar has informed that the members of the high power committee is being formed by the government to address various identical demand of the country all over the state. Considering all, the committee noted that the mandate before it is to remove the disparities among the contractual and provide a feasible long-term solution to the contractual grievances. Firstly, the committee tried to categorize the employees. It is noted that some of the contractual were engaged against the unsanctioned post, such and such. One was engaged against the cadre post, one was engaged without any advertisement, some were engaged with the approval of the parent department. Considering the complexity in categories, the committee decided to consider all the contracts of the same grievances. So the first three agendas before the committee are considered as one and to be dealt with in uniform manner. Agenda 1, pay revision, WBC order 2018. Prayer of such and such, discrepancy in such and such. Prayer submitted by the said employees order number along with order number such and such along with relevant board resolution were carefully perused by the committee. Committee noted that the said orders and board resolution have created disparities among the contractors. Some of the contractors were getting pay equivalents of ROPA 2009, while the others were on considered pay. Further, some were allowed scrutiny of tenure and others did not.
No, all right.
Members of the committee universally agreed that it is not happening.
Why? Where is the reason for withdrawal?
Not at 177. Not just after the three agenda quoted.
Members of the committee
unanimously agreed that WBSIDC ROPA rules. So the organization has a different ROPA. 2020 cannot be awarded to contractual employees of any category at WBSIDCL. Also, the ROPA, past, present, or future, cannot be used as a yardstick or formula for calculation of consolidated pay. as it is clearly mentioned that the ROPA can only be applied for regular employees.
Yes.
Not a completely different yardstick applied here. First of all, ROPA was not employed for these persons. They were still born at a contractual rate, indexing their emoluments with ROPA.
The scale will have to be taken from ROPA.
Put them at the initial stage, give them increments, emoluments.
Let's say for the High Court judges, the fund comes from the consolidated fund. So this pay commission will have no direct impact. But as a scale, it's being adapted by the parliament. The scale is taken, the measurement is taken, the grammar is taken, because there has to be one grammar, one parameter. If somebody wants to frame a different parameter, they can frame it.
So it's index. And that's why the earlier resolution mentioned it as indexing the emoluments.
Yes. So what is the reason?
The previous page. Firstly, please come to the last paragraph on page 176.
Yes.
Kindly consider the penultimate paragraph. Considering all the above, the committee noted that the mandate before it is to remove the disparities among the contractual employees and provide a feasible long-term solution to the contractual employees' grievances.
Before whom? I just point out.
Please.
Firstly, the committee tried to categorize the contractual employees. It noted that some of the contractual employees were engaged against unsanctioned posts. One was engaged against the cadre post. One was engaged without any advertisement. Some were engaged with the approval of the parent department. Considering the complexity in categorizing the contractual employees, the committee decided to consider all the contractual employees as the same for the grievance or prayers made. So the first three agenda before the committee are considered as one and to be dealt in uniform manner. So for the purpose.
So for purpose of considering the issue, they say the contractual employees should be taken one class. Whatever the mode and manner of appointment doesn't matter. Contractual will be a one class, single class.
To meet their grievance or disparities, reduce their pay.
Question is not that. Question is, show me the reason for reduction.
Yes, no, I just read the next. No, that's all. Please see the paragraph beginning with the words members of the committee at 177. Oh, I'm sorry, the next page, the next paragraph. The prayers submitted by the said employees just after the three agenda. Please see agenda item number 3, discrepancies in getting benefit amongst the sub-assistant engineers engaged on contractual basis in engineering division. Agenda item number 18 of 364th meeting of so-and-so on 19th October 22. The prayers submitted by the said employees, order number 108 of 2018, along with order number 50 of 20th July 2015, not the one that I pasted 109, along with the relevant board resolutions were carefully perused by the committee. The committee noted that the said orders and board resolutions have created discrepancies among the contractual employees. Some of the contractual employees were getting pay equivalence of ROPA 2009, while the others were on consolidated pay. Further, some were allowed security of tenure and others did not. Members of the committee and directors of SIDCL unanimously agreed that WBSIDC ROPA Rules 2020 cannot be awarded to contractual employees of any category at WBSIDCL. Also, the ROPA, past, present or future, cannot be used as a yardstick formula for calculation of consolidated pay. So that they are retrospectively curtailing benefits consciously given. As it is clearly mentioned that ROPA can only be applied for regular employees. In supersession of all previous orders and board resolutions, The committee decided to allow an interim relief of 10% of the current gross pay as on 1/9/2023, including ad hoc booster already given in 2020. This was an interim arrangement given till such time the pay was finalized. This will be effective from 1/10/2023. Employees engaged on contractual basis at WBSIDCL, irrespective of terms of.
Mr. Mujumdar, still according to me, I could not find any reason.
But the prelude is remove the disparities and grievances of sufferance. So what would one logically end up to? You have to upwardly revise. That's the logic.
I cannot get the reason. Show me the reason.
I just conclude page 177 and not whatever is there is 177.
That's right.
The monthly remuneration of contractual employees will be consolidated pay in the nature and devoid of any pay scale or its reference. Other allowances like tiffin and conveyance allowance, car allowance, telephone allowance will be allowed as per existing rates and entitlement as allowed by the management. Stop. No other allowance will be allowed for payment. So DA is withdrawn. Order number 108 dated 9/2/2018 and 50 dated 20th July 2015 stand cancelled. So such interim relief is purely temporary in nature and will remain in force till issuance of any order or issued by the Finance Department, Government of West Bengal regarding further financial benefits to any or all of the categories of employees engaged on contractual basis. This interim relief should not be treated as a matter of claim or demand by the beneficiaries at any time. Neither it can be referred or cited as a precedence or right in later period of engagement. Enhancement in consolidated pay will be allowed on 1st July every year.
These are the results.
That's the results.
These are the decisions. But where is the reason?
Only reason is there should be equality amongst the consolidated employees. That's the previous page, 176.
Where is the reason?
176.
That for this reason, this alteration is
last paragraph of 176.
Last paragraph
of 176. This could at best be the reason. Firstly, the committee tried to categorize the contractual employees. It noted that some of the contractual employees were engaged against unsanctioned posts. One was engaged against the cadre post. One was engaged without any advertisement. Some were engaged with the approval of the parent department. Considering the complexity in categorizing the contractual employees.
No, but
the committee decided.
This is just to form a class. So contractual employee was given and collectively made a class. But where is the reason for changing the previous board resolution?
Nothing else is there. Nothing else is
there. There has to be a reason.
No, that is not there. But that's what I am submitting. A decision consciously taken being alive to the rational situation for the purpose of benefit of the organization has been arbitrarily withdrawn. And that is why I argued that it is violative of Article 14. In the anvil of arbitrariness.
Where is the reason? The entire exercise was carried out
for a purpose.
For a purpose. To come to a conclusion to that purpose, all the types of contractual employees was brought under a single roof. Quote unquote contractual employee. Up to this, all right. Then the conclusion. But where is the reason to arrive at that conclusion?
No reason. No reason. And please, apart from the conclusion, please visualize the impact it has. It cancels the 2015 and 2010 decision.
Why?
It cancels the earlier decisions of 2010 and 2015.
By this 2023.
So, decision taken a decade earlier is cancelled. Number one. What is the consequential effect of this? No annual increment. Number one.
That's secondary.
Yes. Adverse affectation with a retrospective effect.
So a right was created 10 years back. After 10 years, you are cutting that right. You are removing that right.
Retrospectively causing an adverse affectation of a right.
Retroactive.
Retroactive. It's retroactive.
It's really a retroactive.
Had it been a statute, I could have argued it's a retroactive operation.
Bring judgments with copy.
And the list of dates.
The list. Wait.
Well, only what? Sorry.
I will first complete hearing him. He will complete. Then I will hear you. Whole hog. Don't worry. And you also get ready with your judgments if you wish to rely upon any. Huh?
Only one thing. My lord was under the impression. My lord was under the impression that decision was taken by the committee formed by the government. This is not so. Kindly read. I have.
And let me also say that I am taking for the time being. It is not a government decision.
It is not a. Mala, kindly consider that minutes of the meeting. Just a minute. I have kindly come to page 176. I will take just 2 minutes time.
It is the decision taken by the board of the corporation.
No. It is the meeting of the resource committee of the WBCI, which is not, the decision is not being taken by the BOD, board of directors of the WBCI.
Then this decision has got no value.
Yes, my lord, that's why, my lord, kindly consider, this, my lord, kindly consider, what is he on? That once the decision has come from the
board of directors,
then he has a right to challenge. Board of directors can take this or refuse to consider that, no, their decision will. Why I am saying?
No. Then, Mr. Sengupta, what shall be the consequence?
My lord, kindly, I know, my lord.
The previous one remains.
No, my lord, kindly consider one thing. My lord, kindly consider. My lord, WBCI management, my lord, what? My lord, page 176.
Yes.
It's very vital. 1, 2. My lord, kindly see who are these are the members. These persons are the members.
I request
My lord, kindly no. Just a minute. You are no. My lord, kindly. It was noted. Kindly see. It was noted.
Kindly. You hear to me also.
WBSID management.
Members of read on.
WBSID management has been receiving.
First heading you receive.
Oh, chairman of the committee.
No.
Minutes of the meeting.
No. Thereafter, minutes of the meeting of.
In chairman of the committee. No.
Minutes of the meeting of.
Minutes of the meeting of resource committee of the WBSIDCL.
Wait.
Yes.
Human Resource Committee of WBSIDCL.
Human Resource, yes.
Now come to the next heading. It's just before the names. Read on. Members of
the Human Resources Committee and directors. Yes, director of WBCI, not the BOD. Board of Directors. Kindly consider what I am on. My lord was under the impression that this decision was taken by the government. No,
I am taking it to be a decision of the board of directors.
No, it is not the decision of the board of directors. It may agree, may not agree. Subject to because why I am kindly consider.
Do one thing.
Yes.
You come up by way of an affidavit. That this is not the direct minutes or the decision or the resolution.
Yes.
Adapted by the board of directors of the company.
Till date, it was not approved. So far, my instruction goes.
No, your instruction will not.
Yes, I'll put that in. Yes.
My lord,
no, my lord, he is trying to, my lord, kindly consider.
The board of directors in the meeting delegated its authority to this committee to finalize. And that's the resolution. Please see 168.
My lord, kindly consider. Board of directors is.
If he being the corporation admits.
He will not give effect to it. Very well.
Matter ends. How does it matter to you?
Well, kindly consider, board of directors, I could have understood, has taken a resolution accepting.
Whatever you are saying, sir,
Yes.
I'm granting you an opportunity.
Yes. Why? Yes.
Our why?
No.
Why you are disclosing?
No, that is one thing. But kindly consider, this is not the, my lord, the committee formed by the government. Kindly see where it is written. It was noted that the members of the Human Resources Committee noted that the management has sent a proposal for regulation of contractual employees to the department. Sri Joyprakash, member director WSA, has informed the members that a high power committee is being formed by the government to address various finances. So it is not that high power committee of the government.
I am saying that I am recording your submission.
Yes.
I am asking your client to file an affidavit.
Yes.
That page 176.
Yes.
Is not a document or not a result of a board meeting of the company.
Yes, that is the final difference. So my lord, he has got no case at all right now.
Ashu.
But my consequential, my lord, do not put into any words.
That's
the my lord, yes.
You listen to me.
Yes.
I'm passing me on. You listen to me. If you have any submission,
yes,
I will definitely then.
And my lord, before that, my lord, only one submission may be noted, because their appointment, as per the government rules, that MSME department, that the parent department, my parent department, approval has to be obtained by the principal secretary as well as the finance secretary. I have in my affidavit, I have
you place everything.
No such approval was.
Yes. You place on affidavit whatever you want to.
This
place.
was
I am recording your submission with regard to 176.
This only part.
You just
and so far others for yes.
No, I'm not at all.
Only yes.
It will suffice.
Yes, in
if you come up with an affidavit in sync of your submission.
Yes.
The principal grievance of the petitioner is that both of you listen to me.
Yes.
That
petitioners.
Is that by virtue of a board resolution of the respondent number?
Respondent number 2 to 4.
No.
Yes, 2.
देखिए.
Yes, must be 2.
Respondent number 2, company.
Yes.
Respondent number 2, comma, which is a company.
Yes.
কি বললাম? Which is a limited liability company, comma, আবার পড়ুন। Limited liability company, which is a company, the benefit awarded to the contractual employees, comma, the petitioners by virtue of page, আচ্ছা এইটা পেজ করো বাবা, আরেকবার পড়ো। পড়ো যা বললুম পড়ো। Dated September 19, 2023, Annexure P16 at page 163 to the writ petition, bracket A, volume 2, comma, the benefit awarded to the contractual employees, comma, the petitioners herein. under the previous board resolution dated, Mr. Majumdar,
5th February 2010,
February 5, 2010,
29th June 2012,
June 29, na, aste aste. February 5, 2010, Annexure P6 at page 77, comma, June
29, 2012.
29, 2012, page, Annexure page.
That's page 80.
Huh? 109.
No, 29 June. Page 84.
84 to the writ petition were taken away, right? Taken away and or modified and altered to the detriment of the petitioner. First step. And paragraph, an immediate response from Mr. Sushobhan Sengupta, learned counsel, appearing for respondent number
224.
2224 to the above contention of the petitioners is that the said resolution dated September 13, 2023 at page 166 to the writ petition was not taken and or adapted by the
Human Resources
Board of Directors.
No.
Not taken or adapted by the Board of Directors.
Board of Directors. Yes.
Of the respondent number 2, but was adapted by the, tell me, human bolt kore. Human HCAP resource HCAP a RCAP committee.
Yes.
Mr. Sengupta.
Yes, yes.
CCAP of the respondent number 2.
Well, my lord will find with page number 168, kindly come second paragraph after discussion BOD, that means Board of Directors, page 68, 168, kindly come 168, second paragraph. It starts with after discussion. The BOD decided to induct C. HKJ independent director such and such director in the HR committee and ordered for convenient meeting of the city council and import the committee for financial division of sales for WCS. So BOD has entrusted that human resources, one of the wing, to consider. So it is not the, because BOD is yet to finalize whether it will adopt or will take it. Different view.
Wait, listen carefully. কি বললাম? He then refers to which page, sir? Just now you have referred
168.
168, second paragraph.
He then refers to the second paragraph at page 168 to the writ petition and submits that the Board of Directors decided to
entrust
the
Human
Resource Committee of the respondent number 2.
Yes.
For convening a meeting of the said committee
For finalization of the revision of salary.
for finalization of revision of salaries of all the contractual employees of respondent number 2. He submits that the Board of Directors has not taken, Board of Directors of the respondent number 2 has not taken any decision as of now on the said resolution dated September 19, 2023, annexure P16
Since the matter is sub judice.
Annexure P16 at page 176 to the writ petition. Since this writ petition is pending.
And my lord, there is an order of
This writ petition is pending.
And
Writ petition.
this writ.
Since this writ petition is pending. Now, so according to you, do I take it that according to you, the Board of Directors of the respondent number 2 has not taken any decision altering the previous one?
No, my lord. My lord, instead of that, my lord, what I am making is humble submission that Board of Directors is yet to take a decision whether to accept.
According to him, the Board of Director of respondent number 2 is yet to take a decision.
Yet to take a decision as to whether to adopt or
slowly as to whether to adapt
these minutes of the human
this board resolution dated resolution of the Human Resource Committee dated September 19, 2023
ought to differ
ought to negate the same
with a reason.
With reasons.
And my lord, one more thing, my lord. The first order, my lord, 30th November 2023, I just point out, my lord, in the observation of the Honorable Judge, there is some substance in the argument of WBS. I made the submission that the grant of any benefit to contractual was outside the scope of rules of the corporation. Kindly take note of, because my submission may be noted.
He further submits that
question of I am reading then, my lord, the question of continuance of benefits does not and cannot arise. Petitioner cannot claim to continue the benefit out of illegality. It is argued as such by reference to the principle there is no estoppel against the law. It is further argued corporation was not only seeking to rectify a wrong committed in the past, the contractual cannot by any stage of a claim any pay band, basic day HRA, the question of applying to contract doesn't arise. This court, however, not ignored. Now, my lord, but my lord, kindly take this portion of the order of
it is not part of the petition.
No, because in this writ petition, the order.
Recording date ফেরত দিয়ে দিন এটা. You keep
it. Sorry, it is marked.
No, you keep it with you. Give me the date.
30th November 2023. Honorable Justice Rajshekhar Mathur. Paragraph 8. Paragraph 8. There is some substance.
Right. This is on merit. But I wish to have an affidavit from your client.
Only
to the extent you have made submissions.
Yes. This kindly take note of it, because the honorable coordinate bench, has accepted my submission. There is some substance in the argument of WBS.
Correct.
Yes. Kindly take note. Kindly take note of it. Paragraph 8. Page 3, paragraph 8. Kindly.
But no affidavit in opposition filed.
Yes, affidavit in opposition filed. I have used affidavit in opposition. Only to that extent, my lord, already.
No. All right.
Exchange. Affidavits are being exchanged. Yes. Only to that extent, my lord was of the observation, Mr. Sengupta. If it is not, then my lord, there is no case at all.
No case in the writ petition.
Yes. Kindly.
In support of his contention,
obliged,
Mr. Sengupta has relied upon his previous submissions as recorded in the order dated November 30, 2023 by a coordinate bench, which runs as follows. Quote করে দাও। এই paragraph 8. Paragraph 8 from the order dated 30th November 30, 2023. কোট লিখে রাখছি আমি, হ্যাঁ। হয়ে গেল paragraph. In view of the above, where is the managing director? Respondent number 3 is directed to file an affidavit in support of the stand taken by Mr. Sengupta today in court,
To that extent,
as recorded above. As recorded above in this order. Such affidavit shall be filed. Tell me when?
At least 2 weeks.
On or before aaj ko tarikh. August 5, 2025, upon a copy being furnished to the learned advocate on record for the petitioner. Paragraph, the petitioner shall be at liberty to file a rejoinder thereto, a counter affidavit thereto. On or before?
1 week.
August 12. August 18, 2025. লম্বা ছুটি আছে। August 18, 2025. The writ petition shall appear under the heading কিসে আছে? For hearing. On August 19.
Kindly a date may be fixed so that, my lord,
19th.
We are eager to, my lord, argue before
19th.
19th, yes.
এই ওইটা কবে রাখলাম?
ওটা উপরে করে দাও।
আরবিট্রেশনটা কবে রাখলাম? সেদিন রাখা যাবে না। পারো তাহলে August 19. August 19. Absolutely, get ready.
Apart from that, apart from whatever my lord can, or my lord can, if you, my lord, decide, my lord will take a decision.
Does the affidavit come? Let the affidavit come.
Obliged, my lord.
Thank you.
That may I?
Oh, yes. Thank you. হয়ে গেছে তো এটা? শুধু অ্যাপ্লিট সাইট কি আছে?
অ্যাপ্লিট সাইটটা আমার আছে এক নম্বরে। রিভিউ
ডিসমিস করে দিয়ে উঠে যায়।
all right. Kindly rise. Next matter is mine.
আরে ডাকুন না, পাস ওভার করে দিয়ে বেরিয়ে।
আমার কাছে জাজমেন্ট নেই।
দেখো না, লেটস তো পড়ো।
Whatever judgments,
that is
whatever judgments you
yes,
will
yes,
bring with the Xerox copy.
Yes, always. I am a Supreme Court judgment. It has come.
And same for your other side.
আমার হবে না, আমার তিনটে লাস্ট।
And same for your other side.
Yes, yes.
Mr. Sengupta, inform your other side.
Mr. Mujumdar knows that.
He knows.
Yes, of course. He is doing service matter while a regular.
Why he behaves so innocent?
Always, this is his gesture. We should appreciate.
Advocacy.
No, advocacy, it is not an advocacy.
Gesture, that's right.
কিছুই জানে না। Three to five.
একসঙ্গে আছে করে দাও
3 to 5. দাঁড়া আমাকে
কি মামলা?
this is contempt application has been filed. Just
a contempt.
No.
Is this
Yes.
contempt?
Based review. Contempt application has already been filed, and after that I filed a review application as well as application for stay. My lord can say, my lord, Mr. Sengupta, why section 5? I say, my lord, I have the judgment because
Section 5 has been filed.
No, it is not required.
Not required.
This is the division bench judgment following should be I appear. My lord, our honorable high court. I can
All right.
place
I will hear you on the next day.
Yes.
Next. Fast over.
The petition
Oblige.
is suffering since 2016. That is our agony.
কি কোনটা রাখলেন? 6. Fast over.
No, I'm saying is here. No, 6, my lord, I have filed a report, my lord. I have paid the money, and he has, at that point of time, my lord, he has said, I have not received. Lordship, would I file a report?
Lordship, on such occasion, Lordship, that information I have gotten, but your Lordship.
Have you been paid?
Lordship.
Bas, ঠিক আছে।
Chal, the report done.
What do you do if your client does not give you correct instruction? So the writ petition is disposed of. Ashun.
A writ petition is dismissed, should be dismissed with cost.
Cost.
Because my last occasion is in.
How much interest you have paid?
Whatever the interest, absolutely I have paid.
No, you paid
no
for
delay,
cost.
no delay. The last occasion,
Ashun. Just go with you.
matter will be disposed of today.
The last order dated June 30, 2025 speaks for itself. Paragraph pursuant to the direction of this court dated June 30, 2025, an affidavit has been affirmed and filed today on behalf of respondent number 3. Full stop. The affidavit is taken on record. Full stop. Copy has been served upon the learned advocate on record for the petitioner. Paragraph. The affidavit confirms Mr. Ashok Kumar Jena, learned advocate appearing for respondents, relying upon the affidavit, submits that the entire payment has already been made.
Prior to filing of the writ petition.
Much prior to the filing of the writ petition. Paragraph. Mr. Vishwambhar Jha, learned advocate, appearing for the petitioner, on instruction from his client, has confirmed the said fact of payment. Paragraph. In view of the above, nothing further survives in this writ petition. Paragraph. Accordingly, this writ petition bold WPA 13340 of 2025 stands disposed of, without any order as to costs. Since affidavits are not called for, allegations made in this writ petition are deemed. No, affidavit to call for করেছি হয়ে গেল। Yes.
Lord, a widowed daughter, Lord, with your lordship, Lord, to claim pensionary benefit.
Family pension.
Family pension.
From respondent. Port trust.
Yes, from
Port trust. Where is the representation?
Lord, the representation, Lord, has been rejected. Demand justice at page 26.
Why rejected? What is the ground?
In 2022, immediately thereafter, Lord, I filed.
Grounds for rejection shown to him. Show it to him. Show it to him. Show it to him. And tell me.
Page 36.
What's the reason for rejection?
Rejection is not certain papers. Oh, the nomination was not there.
What happened? बोले नहीं तुम?
हाँ, simple.
The
I'm
deceased
claiming my
initially the deceased employee, my lord, the wife of the deceased employee, he was getting pension.
wife.
Wife
Widow,
of that
widow.
widow was getting pension upon submitting his pension book and
Whatever.
nomination papers. Here, my lord, in 2009,
when the widow died,
2009 and 2019,
the daughter came.
family pension.
Married daughter.
I do not know, nothing spelled
widowed
out.
daughter.
File a report.
No, widowed daughter, it's on record.
All right, file a report.
In that event, করবি FSCO কে বলবি consider করতে
হ্যাঁ সেটাই better.
financial advice FSCO is not the party. It's not, you can do not record my submission.
No.
Financial advisor and chief accounts officer. He's the senior most officer.
Wait. It will be my direction. Ashu.
Chief senior accounts officer.
Ashu.
Chief senior account क्यों नहीं?
Show me the rejection.
No, the rejection is at page 36.
36.
And not the notification based on which I am claiming is at page 20.
Not required. Who denies that widow family pension provision is not there? The solitary grievance in this writ petition is that the widow daughter, please listen to me. The widow daughter claims family pension as her father was as her father was an employee of Port Trust Authority. Full stop. কি কথা বলছে? কথা বলতে পারুন কম। কি বললাম? As the deceased father was an employee of Port Trust Authority. Paragraph. The deceased died on?
The deceased died on, my lord,
Deceased employee died on?
January 11, 1999.
January 11, 1999. Full stop. Then the widow, being the mother of the present petitioner, received family pension. Full stop. Thereafter, the widow died on
16 November 2011.
November 16, 2011. Full stop. এগুলো ইয়ে করতে থাকবেন, date bold. When she became widow?
Lord, she became widow, Lord, on October 13, 2009.
October, কোথায় পেলি বাবা?
Page 43, death certificate.
Certificate, all these certificate, my lord, very.
Husband's death certificate?
Yes.
All right. কি বললাম? Full stop. এই ডেট গুলো bold.
জানি না ভাই।
The husband of the petitioner died on?
Lord, died on October 13, 2009.
October 13, 2009.
And when he has filed the application?
Comma. The death certificate is at page? Death certificate of the husband of the petitioner is at page 43 to the writ petition. The petitioner then applied for family pension on
12 July 2019.
July 12, 2019.
Page 23 of the writ petition.
Date bold. Short date bold. Date উপরই মামলা হবে. At page 23 to the writ petition. The claim of the petitioner, paragraph. was rejected by the impugned order dated November 29, 2022 by the Port Authority, Port Trust Authority,
আচ্ছা দেখো তো বের করো চিঠিটা লেজিবল কপিটা কোনটা এটা দাদা তুই দেখতে হচ্ছে আমারটা দেখি কি দেখা যাচ্ছে না দেখি আমাদের দিকে আমাদের না না
following observation. Quote from page 36. Quote 1, huh? Oh. Sorry. Quote 1, huh, Didi? Poster. Paragraph.
Not one more document perhaps with
Miss Matharopur, Mr.
Rahul Kaur.
Rahul Kormokar, Learned Counsel, appears for the petitioner. Tapor Mr. Ashok Kumar Jena, Learned Counsel, appears for the respondent Port Trust Authority. Even ekdom niche ashun. Yes.
Not page 46 is a certificate granted by video, not of the concerned block, not indicating.
You will produce all those.
This
You will
I am
produce.
not accepting.
I am not recording.
Yes. Then
তুমি চেঁচাবে
আমি ওর ভালোর জন্যই বললাম অত ভেতরে গেলে তাহলে আমাকে বলতে হবে অনেক কথা
by the impugned communication dated November 29, 2022 with the following observation. হয়ে গেল? এবার লিখুন। On perusal of records and the impugned rejection, it appears that one further opportunity shall be granted to the petitioner to establish his claim,
But
her claim, before the appropriate authority. Full stop. As the law is well settled that family pension is a matter of right of the beneficiary in accordance with law, if the beneficiary can prove that he is the
Dependent.
beneficiary of the scheme.
So he has annexed a circular. That's
If he is the beneficiary of the family pension scheme in accordance with law before the appropriate authority. Paragraph. একটা দু লাইনের তোমায় রিজন দিতে হবে কেন আমি রিকনসিডার করতে বলছি। Paragraph. Accordingly, the impugned communication dated November 29, 2022 stands set aside and quashed. Set aside bold, quashed bold, enter normal. Paragraph. In view of the above, the appropriate authority of the Port Trust, Kolkata Port, of the respondent Port Trust, being
financial advisor and chief
bold করে দেবেন এটা financial advisor F cap A cap
financial advisor and chief accounts officer
and chief accounts officer comma
Shama Prasad Mukherjee Port Kolkata
Shama Prasad Mukherjee
Port Kolkata or chairman ঠিক আছে ওই থাক
ব্র্যাকেটে the said authority
আমাকে দিবি চেয়ারম্যান এদের করে দিলে তোর কাজটা এগোবে
চেয়ারম্যান বলে দাও
না বেশি
shall consider the case once again.
ইগোর ব্যাপার চলে আসছে
Shall consider the claim once again. Full stop. Paragraph. The petitioner shall forthwith submit a copy of this writ petition along with a copy of today's order before the said authority. Paragraph. The said authority then, upon issuing a prior hearing notice of at least 7 days to the petitioner, and after granting her an opportunity of hearing, shall decide the claim by passing a reasoned order in accordance with law. Paragraph. The entire exercise shall be carried out and completed by the said authority positively within a period of 6 weeks from the date of communication of this order. And the reasoned order shall be communicated to the petitioner positively within a further period of 2 weeks. From
instead of 6 weeks, can it be 8 weeks now?
8 weeks. Within 8 weeks, a reasoned order shall be communicated to the petitioner positively within a further period of 2 weeks from the date of the said reasoned order to be passed. Paragraph. It is made clear that this court has not gone into the merits of the claim of the petitioner or her right and eligibility with regard to her claim.
Since no affidavit filed,
Paragraph. ওর সঙ্গে the petitioner and the authority shall be at liberty to consider their respective issues on the basis of the available materials and records while deciding the issue. Paragraph. It is needless to mention that the petitioner shall be entitled to attend the hearing along with her one authorized representative, duly authorized representative. Full stop. Paragraph. In the event any further document or record is required to be produced by the petitioner, comma, the said authority shall be at liberty to call upon the same at its discretion, and the petitioner shall produce the same before such authority. Paragraph. It is made clear that this order shall not create any right or equity in favor of the petitioner, comma, if the petitioner does not succeed to her claim before the said authority strictly in accordance with law. Paragraph. Since affidavits are not called for, allegations made in this petition are deemed not to have been admitted by the respondents. Paragraph. Full stop. With the above observations and directions, this writ petition, bold WPA 876 of 2023 stands disposed of, comma, without any order as to cost. Ekdom mathar opor affidavit of service filed in court today is taken on record. Thank you. Thank you, Mr. Jena.
unnecessary matter will be pending of the
No,
affidavit.
and this is the corporation, and this is the act of an officer of the court, just to give the proper authority.
So that's why I told the financial advisor and chief, he's the senior.
Absolutely. Absolutely.
So he's not a party here. Even then
Poor lady, if he gets as of right.
we are not.
Absolutely.
We are not standing with the one person will get a family
But
pension.
unless
Some procedure is there. Some documents are required.
That's his
Mandatory.
I said,
Yes.
if any further document she will produce, if she cannot, adverse presumption.
We are always ready.
Absolutely. Thank you so much.